arising out of section 9 of the arbitration.
Yes. Well, the interim order is expiring on 15th of December. It's item number 165, 166, 167.
I have given a notice for this.
Expiring on
15th of December.
It will appear on 15th of December as under the hearing extension of interim. At the top.
Yes. Under extremely compelling circumstances with respect to item number 159 of today's case.
Yes.
Milord, what happened, Milord, Milord, and non-maintainable in an appeal. Milord, this appeal is not maintainable. Milord, this was not apprised to my lord. Milord, an interim order is passed, Milord, where, Milord, I am suffering every day, Milord, a lack of...
File a vacating will take the...
We have filed, that is can 2 and can 3. Milord...
so then we will direct this to appear under the hearing application.
Yes, Milord, once it is appearing as under the hearing application, but Milord, I am seeking, Milord, every day, Lord, Milord, there is a season where, Milord, my restaurant runs. Milord, my lord has directed the running of the restaurant. Milord, but the legal license, Milord, which is granted to me, Milord, on a daily basis, Milord, there is, Milord, an order of status quo form or an injunction has been granted by my lord. Milord, this is where, Milord, troubling and the appeal is not maintainable. And we were on caveat. Milord, without serving us, this order was obtained.
Will direct this is appearing under the hearing application only.
Application 159.
Cannot give precedence within the application list.
But yesterday it was appearing.
There are other matters also which you have refused.
Well, yesterday it was appearing as to be mentioned, but since it was in to be mentioned, it went to application.
Mr. Chatterjee, no objection.
No,
No
every
objection.
day.
No objection. Yes.
Your Lordship, I'm mentioning one item for inclusion for stay application.
My lord, may I have my lord's leave to my lord file and move an urgent appeal? My lord, this is an ex parte ad interim order passed by the City Civil Court. In respect of
Leave.
My lord, leave because certified copy. My lord,
Leave
also
is granted, it will appear on Monday.
my lord, one other humble my lord, there on caveat I'll have to serve. Could it appear on Tuesday, my lord? Because I'll have to serve and come.
Tuesday.
One other leave, my lord, humble prayer, my lord. The suit was filed on 11 November 2025. The impugned order incorrectly mentions the date as September 1109, but the suit was filed on 11th November. That the department won't accept. They'll say that it's a delayed appeal, but then it's within time, my lord. I'm coming within the 30 days period, my lord.
The filing cannot be refused by the department.
My lord, if a leave only could be endorsed for it to be taken on record, my lord. That's all. We've pleaded that in the stay
It is
application.
granted to file the appeal without certified copy and in its present form.
Obliged. Deeply obliged. My lord, could it appear on Tuesday only? My lord?
Tuesday. Yes.
Application.
Yes.
My lord, for inclusion order 41 rule 11.
Yes.
May I permit to mention two matters for inclusion in the list, matrimonial suit.
What is this, application or appeal? Appeal hearing. Appeal hearing, not right now. Yes.
So this is an inclusion in list appeal hearing, title suit.
No, not right now. Call on list.
My lord, these matters come up at my instance. My lord, the respondent in the appeal, my lord. There was a direction on 4th November 24, 2024 by this bench, my lord, your lordship bench, to file paper book. Now, my lord, the department never intimated that paper books had been filed or served. It was never served. When we tried to inquire from the department why the file is not being sent to the court for enlistment, when we mentioned it last Thursday.
The sole respondent's advocate has been served.
It has been served only yesterday.
Yes. So why do you mention? Mention for that, for service?
Yes, because they were delayed by almost 7 years, my lord, in filing the paper book.
Anyway, now since it has been served.
My lord, let it be. This is a senior citizen lady, my lord. Could it be added in January, my lord?
No, Mr. Mal, not right now. Not right.
My lord, lordship will kindly, my lord. She is out. In spite of getting an order of recovery of possession, my lord, she has to stay with relatives or guest house, my lord.
Not right now, Mr.
Could be any down in the list, my lord, in January, my lord.
No. The matter was mentioned on behalf of the respondent since no copy of the paper books were served on the respondent. However, it appears from the office report dated December 9, 2025 that in the meantime, copy has been served. Accordingly, let the matter go out of the list since no further order need be passed in that regard. With liberty to mention for inclusion in the list in the month of January 2026.
My lord, I'm filing the written. Thank you. My lord, don't make me amiss yesterday because
you are arguing.
Because I will come up with again. My lord, I will distinguish that.
Yes. Written notes of arguments filed by the parties be kept on record. Be kept on record. The appeal is reserved for judgment.
Obliged.
Thank you. পাঠিয়ে দেবেন।
ওখানে ওরা সিটে আছে, দিয়ে দাও নামগুলো দিয়ে দাও।
Number 3.
Appear for the appellate, my lord.
Yes.
নামটা দিয়ে দিচ্ছি। ডেট কোথায় গেল?
কি জানি?
আচ্ছা, শুদ্ধদেব আগে।
Nobody is appearing today for the respondent state. My lord, may I proceed, my lord?
আমি কল করছি।
No, no. Yeah, if the respondent does not appear, what can you do? You
আমি
proceed.
আমার নিয়ে কল করি।
এটা কোনো নোট ফোর্স নেই কিছু?
He's coming on his way, I think.
পেপার বুকের মধ্যে আছেন।
I am requesting him to come before this court, my lord. So my learned junior, he can communicate. So that
No, no, you start. You start. No difficulty. We'll hear you. If they don't come, we'll hear you and close the
my
case.
your lordship, in the earlier occasion,
Yes.
can recall that I was submitting on a very small point that whether this allotment in this particular context is concluded agreement or not. The allotment letter was issued. In short, I am just recapitulating the matter. The allotment letter was issued, that is offer letter. On 30th of October 1981, that is page number 47 onwards.
This was an offer letter for allotment of?
Allotment of a plot. I wanted a leasehold plot, lease to be given by the authority.
Is in Vidhannagar.
Vidhannagar. So that matter, my lord.
It was refused.
Yes. Ultimately,
Refused or recalled, initially granted and then recalled.
allotment was offer for allotment was given.
Then
Condition was that you pay the 50% at the time of
you paid the
application,
50%.
paid the 50%. Then they will say that I will raise demand upon you. You will pay the balance amount. I paid that amount also. Thereafter, some delay was made in respect of the payment because they did not raise the demand. That is why some delay was there on my part. On my particular, they charged on interest. I have paid the interest amount, delayed payment of interest. If the balance salami was paid on December 1988, that is page 53, 55, 103 and 104. Thereafter, interest paid on 10/1/1992, page 58. Now, my lord, up to this end, they have accepted my interest. Chalans are all annexed.
You have been given possession.
Not yet, my lord. No
So
physical possession.
then they recalled it on the ground that you have
Then-
suppressed.
Then recall is on the ground of suppression that I, being a minor, represented my age falsely. One plot was identified by me, knowing fully well, accepting. Thereafter, ultimately, order was passed. That is page number 68 by the authority. Kindly look into that. My
They
lord,
took
there
the
is-
point that you were a minor, therefore they could
Yes.
not be given. And you suppressed your age.
I have already.
So your argument was that this is not a contract. Allotment
No,
is not
my
a
argument is that first of all, I did not represent it falsely that I have stated I am a minor. That is in page number 42. No new, they are not, they cannot claim that I have suppressed. Page 42. My date of birth is 21st of November 1968.
Right.
This was the letter I have stated. Ultimately, they found from my passport that this is the correct date. Thereafter, my lord, kindly see, they asked me to pay the money. I have stated page 45.
The money there is no dispute from there and
And my minority is also not, should not be a dispute. Kindly come to page 45.
their reason for refusing is that you are not entitled because you are a minor and you suppressed your age.
But I have not
Say
suppressed.
you have not suppressed, and moreover that this allotment is not a contract, so that it is vitiated under the Contract Act.
And that I will show your lordship the
Allotment can be made in favor of a minor also.
my submission. My respectful submission, kindly look into page number 45. After 40. I am a minor. I will cut short the case. I will go directly to the law point.
Yes.
As I am a minor, you have asked me to, page 45, I have clearly stated to them, this cannot be a ground. I am a minor. You have asked me to submit a letter of undertaking for payment of the salary. And so my father is concerned with the plot of so and so. Accordingly, I am submitting. Here
After
is
this, they took your salami.
Uh,
After this, they took your salami.
yes, yes.
Even after this,
Yes,
after
yes.
discussion.
It is very initial, before the first salami paid. Before the, I expressed.
So very well. Let us
So
now.
this point
Yes.
is suppression ground. My restful submission does not apply to me.
Very well.
Kindly come to the offer of allotment. Offer of allotment will appear in the page number
105.
kindly look into my lord. My lord, kindly page number 47.
Page 47.
47. This has been typed because some 47 is not legible enough. I want to submit that what is the scheme of this particular proposal. First, your lordship kindly look into. It is a letter of offer of allotment. Letter of offer of allotment.
After salami is deposited, you will have to enter into an agreement with government. That is clause D at the end. You place that on the last page.
Yes, my lord. My lord, then kindly see the clause D, salami part, so and so everything is over, an agreement with the government accepting all the terms and conditions. So I have come to know some of the judgment related to the share certificates where the definition and context of the allotment of the shares are different. They are said that after the allotment of the shares, it becomes the allotment means that some shares are being allotted to you and shares comes into existence at the time of allotment. But so far the plot is concerned, if I say that it is a allotment letter is some instrument, if I, for the sake of argument, then it must be registered one. There is no question of registration of this allotment letter. It is an offer of allotment. And that allotment, after depositing the entire amount, they will come to an agreement with me. That agreement will bind both the parties. This is my submission. Then kindly come to, because there was some delay, ultimately, the page 105, the allotment offer was revived. Kindly see 105. My lord, 105. May I read, my lord? Okay. With reference to your letter date, so I am directed to say that as you have failed to pay the balance salary in 3 years from the date of the offer of allotment, order under reference, the said offers stand cancelled as per the terms and conditions. However, after careful and sympathetic consideration of your difficulties mentioned in your aforesaid letter, I am directed to, by the order of the governor, to say that the governor has been pleased to decide the order, the offer of allotment under the reference will stand revived. So this offer revived. They clearly state is an offer. And after that, question came in my mind that whether a transfer can be made in favor of a minor. I think that I did not to place any judgment. It can be done. Second thing is that whether there is an agreement came into existence till date, no. Whether I have paid the entire amount, yes, I have paid the entire amount, including the penalty interest. Thereafter, my lord,
But Mr. Banerjee, you yourself say that this is not registered, so this is not a transfer. It's an agreement. If it's an agreement, agreement is a contract.
I'm not saying it is an agreement, it is an offer. Agreement will be made between the parties only clearing the...
You accepted the offer by putting in the salamis and all.
That is one part.
So then it's a concluded contract which you could not enter being a minor.
My lord, it may not be a concluded contract as per my respectful submission.
What is the status of that document then, that transaction? If it's not a contract, not a transaction, not a transfer, then what is it? You are not entitled to enforce it in law then. Either it has to be a contract which is enforceable in law, or it has to be an outright transfer. It is obviously not an outright transfer, which you are saying also. It's not a registered. So therefore, it has to be an agreement for you to have the fruits of that. Otherwise, you cannot enforce it in law.
I'm
You
not,
cannot say in the same breath it is not an agreement nor a transfer. If it's neither, then you don't have any right under it.
maybe if it is termed as an allotment is an agreement.
Allotment is not a separate genus of transaction. Either it has to be an agreement to enter into a transaction, enter into a transfer, or it has to be the transfer itself. It's not a transfer, it's obvious. You are saying, we are saying. Then it has to be an agreement for you to have it fulfilled. An agreement cannot be entered into by a minor. That is their point. So how do you overcome that? That
So,
is the ground on which the learned single judge also dismissed.
Single judge took this allotment as a contract, and section 11 comes into play.
Section, yes.
11 that the minor cannot come into the contract. Now, my lord, the equitable principle, according to me, there is no binding agreement till date. Because agreement, according to
Say
me,
that then you are not entitled to have that enforced by a writ petition.
I only say, my lord, we respectfully submit that they are required to execute one agreement with me. They did not do that.
What does your right to get an agreement flow from?
So from the after deposition of the entire amount, there are
Therefore,
only
it flows from this offer letter and your acceptance
offer
of
letter.
it. Then it's a contract. We come back to square one.
Yes. And in that
Your writ petition was for a direction upon them to execute a registered deed, lease deed in your favor, right?
but no agreement, no agreement.
If there is no agreement, you
Formal
don't have a right then.
No agreement. My respectful
If there is no agreement, then you don't have a right.
Then my lord, agreement.
In law, there is no right given to you.
Yes.
That under the law, this law, I am entitled to a transfer.
Yes. My lord.
Either it has to be an agreement or
that is to be adjudicated whether this allotment is agreement or not.
If Mr. Banerjee, you say it is not an agreement, your writ petition fails on that count only. If there is no agreement between both of you,
then my lord,
why should it be registered in?
Then my lord, I need not to show that much of judgment, but I can say the proposition of law submit that so far there is no agreement. The equitable principle of promissory estoppel, they have accepted money from me. They have given me assurance that, first of all, they have given me assurance that I will allot the plot.
Can there be an equity against law?
In particular case, when there is a minor who has been assured, kindly, my lord, I will not take much time on this issue, that somehow assurance has been given.
Where there is a specific law barring a minor from entering into a contract, can we resort to promissory estoppel? Promissory estoppel has to be given the status of a contract, promise against promise.
One judgment I can show you, lordship, for consideration. My lord, if this judgment comes, because I want, what is the case? They did not first say anywhere that I will not make contract with you first. They did not say by issuing any notice that your offer letter will be cancelled. They asked me for the hearing without any particular agenda. They have asked me that you come up with your all documents, records. I will decide on your allotting the plot in your favor. I will decide. In course of that decision, without finding the fact, the judgment has been passed. Judgment is also passed by non-application of mind. It is not a case of suppression. It may be a case of
suppression. We are not going by suppression.
Yes. So, my lord, this judgment may somehow help us. Somehow.
Show it.
My lord.
Give the citation for them.
Yes, yes. It is a very old case.
And here, there are two judges sitting here. Devanina.
Yeah, I am giving you.
Devanina.
I am giving it to you. My lord, I am just lost it from my.
If you have one copy, don't.
No. I will cite. I will give. I will. Just, my lord, give me 1 minute. It has been left somewhere.
Spend some money on juniors.
No, they are there, but the thing is that it is a change.
You have to have more juniors. You are earning sufficient.
My lord, I have the everything, my lord. Only thing is that, my lord,
only apart from the 2 copies of the judgment.
Change brief. That is why I could not arrange all these change briefs. Even from the order itself.
Yes.
After filing the appeal, the brief came to me. My lord, kindly see page number 746, 747. I did not to read.
Page
747. How the law has changed in favor of the equity. In a particular case, when there is a contract in respect of a minor, if the minor is deceived or the minor deceives somebody, no difference. And the equitable principle of compensation.
Let us see what you are relying on. Which portion?
Start from page 746. The last 2 lines. It is not which is not always easy to reconcile. Have you lost it? Got it?
Which is not always, it's
And
the
the
middle of a
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 from 14th line from the bottom. As in India. As in India.
That's the middle of a sentence. Start from the sentence, beginning of the sentence.
Yes. It is not, however,
Yes.
necessary to discuss the details which bear on the point and which it is not always easy to reconcile. As in India, the jurisdiction of the court to require a party whose instance the instrument has been adjudged to be void to make any compensation to the other party, which justice may require, has been expressly recognized by the legislature in section 3941 of the Specific Relief Act. It will be noticed that this power to grant compensation is not confined to those cases only in which the instrument related to transfer of property, nor is the mode in which the compensation is to be given is defined. The discretion of the court in the matter seems to be absolutely unfettered. They might therefore, in appropriate cases, while adjudging a deed executed by a minor to be void, order a refund of money, consideration received by him under the contract in addition to make him restore any other benefits which he has derived. Here the just opposite case, minor deceived somebody. In this case, minor did not deceive. It is no doubt.
This says the discretion of courts in the matter seems to be absolutely unfettered. They means the court might therefore in appropriate cases while adjudging a deed executed by a minor to be void, order refund of the monetary consideration received by him under the contract, and in addition make him restore any other benefit which he has derived therefrom.
Therefore, I am reading it, my lord. But in addition to make him restore any other benefit, therefore, it is no doubt that in section 3941 relate to those cases only in which the minor is the plaintiff. But that does not affect the question of jurisdiction of the court to grant equitable relief, either by way of restitution of the property in specie or by the refund of the money, with or without the interest. Of course,
we may consider directing the money to be refunded.
That is one aspect. But
that's the only aspect covered by this judgment.
No, my lord. There is some hint that there is no. It is left to the discretion of the court to award the compensation.
Restitute and grant compensation.
Compensation.
If a deed is adjudged, contract is adjudged to be void because it's executed by.
It does not.
But all the same, it reiterates the proposition that it has to be adjudged as a.
My lord, here I absolutely submit that if I go through the few paragraphs, it will clear that.
Place the relevant paragraph. Why are you reading these then?
No, my lord, this is otherwise I cannot come to the conclusion how the logical conclusion came to this.
We'll think about the logical. Where has it been held that a minor can enter into a deed?
Leaving few paragraphs, leaving few paragraphs.
Yes.
But it does not seem to me to open a doubt that the court in this country possesses the power to compel the fraudulent minor or to restore the benefit derived from him from a void contract. This was recorded as a Punjab so. Then next paragraph. It remains now noticed to the subsidiary question whether the power of the court to the order restitution is limited to those cases only in which it has been moved by the minor himself, whether before or after attaining majority, or whether the court can grant relief also when he is a defendant. On this question, again, the authorities are not uniform, but after giving the matter my fullest consideration, I am of opinion that there is no justification for making such a distinction. There is no distinction whether minor is a plaintiff or defendant. It is not, no doubt, true that the section 41 of the specific relief relates to those cases only where the minor is the plaintiff. But in terms are not exhaustive, and I fail to see that why the equitable jurisdiction of the court should be affected by the fact that the minor comes before it as a defendant. The court exercises power to complete the justice between the parties. Then, my lord, next paragraph for the foregoing reasons, my answer is to that. The circumstances stated that in the question, the quantum minor is not stopped from splitting his minor.
Judgment says that either the minor is a plaintiff or a defendant.
No distinction.
No distinction. If it is adjudged that the contract is void, if he is the beneficiary, he has to restitute.
Yes,
if otherwise, then he has to be restituted.
And the judgment also
says, it says reiterates the proposition that contract will be void if he is a minor. It is not a judgment on that.
Yes.
It will be adjudged to be void,
even
but he will be restituted.
Here the contract has become void or voidable at the option of the respondent.
No. Sorry, it's void ab initio.
I will so. If it is so, knowing fully.
What is behest? A contract entered into by a minor is void ab initio. Only relief which can be granted is compensation can be paid.
Paid with the interest.
With interest has not been stated here, but
No,
you have
yes.
not claimed for that. Your writ petition is not for damages. We can
Not for
grant you
damages.
liberty. We will affirm the order of the learned single judge saying that the contract was void, but we'll give you liberty to initiate a money suit for damages as well as for recovery of the money, and your limitation may start from this day, the day we adjudicate the matter.
My lord.
That we can say because your right ripens from this day. Before that, it was sub judice. That at best we can do for you.
Yes, that is one aspect. I'm keeping.
Or
this,
we can even direct the amount which you have paid to be deposited to them, to be paid back to you by them. And for damages, we can give you relief to file a suit and restitute only the money part, money component, because they knowingly will be hearing him, Mr. Adok. After that, we'll do that. If he fails to satisfy us, otherwise. Because they knowingly keeping their eyes open, they entered into, you disclose that you are a minor, still they entered into that agreement.
Yes, my point is
So
that.
therefore, that's why we are of the prima facie opinion that you are entitled to get back the money which you have paid. Interest or not, we are doubtful on that because you also entered into the agreement. It was your fault also. So why should they pay interest to you?
So for the
And it was sub judice before us till so long.
it was sub judice.
Interest probably we won't grant you, but for damages for the loss to you, we may permit you to go before a sale. If you can show damages you have suffered, your relief lies in damages, not in a deed being registered to you, and that was not the relief you sought in the writ petition.
That is well. Otherwise,
Then let us dispose it off after hearing Mr. Adok on this.
One other point I place my note. Other point, my lord, the offer when revived. Now is revived. I am submitting that offer is not a concluded agreement. I am submitting with resolution submission because
We accept your submission, but then you don't even have a right to damages.
No.
Because why we are saying this, Mr. Banerjee,
Yes.
is you don't have a valid agreement between yourself.
No.
If you say there is no agreement, then you don't have a right. Your entire right flows from this contractual, this agreement.
My lord, during this pendency of this matter before the authority concerned, they revived. When they revived, I became a major. They revived it. That offer is revived.
Help you.
So this offer will be counted as a new proposal or the continuation of the old because they cancelled it.
You are permitted to apply afresh for an allotment now. You have become a major. But at the time when the contract was entered into, that is a relevant point of time you have to decide on. Because then you were a minor, Mr.
Then first time I was a minor. When it was revived, I became a major. When after cancellation, they cancelled it first. Then
it was revived, you had become a major.
That is
your date of birth.
The date of birth is my lord, page number 42.
Page number 42 is a page number. What is your date of birth?
I am coming to.
You help him. You are sitting there idle.
My lord, date of birth is 21st of November 1968. And the allotment, when it was cancelled and further revived on the date of 21st November 1968.
68. So on
88
1st of November 86, you became a major. Let us see the date of this revival. 105, 1988. So that was after you became a major.
So that time they knowing fully well permitted me, and the contract was not came to an end. A few new contracts started as for me. If it is an allotment, is a contract.
It's not a new contract. You had already paid salami. This says balance salami.
Now they have said that it was cancelled.
What have they said?
With the reference to your letter dated so and so, I am directed to say that as you failed to pay the balance salami within 3 years from the date of the offer of allotment order, under reference to the said offer stand cancelled. Offer was cancelled. Again another offer was given.
Read the next line.
And as per the terms of the condition, however, after the careful sympathy consideration, difficulties mentioned in your letter, I am directed to by order of the governor to say that the governor has been pleased to decide that the offer of allotment under reference will stand revived.
Revived? What does this mean?
When this is cancelled, one offer is cancelled.
Revived means the cancellation is cancelled.
And
Revived means your original offer is revived, not a fresh offer.
whatever they may say, my lord, my full submission, they may say that. And
Whatever they say,
uh,
that is there in that offer, and you are proceeding on that
and
terms.
my submission is that when it is stand cancelled for any reason, thereafter they accepted money, again this revival has been given.
Revival means something which was dead has been revived,
They are
given life.
Yeah.
So therefore, revival, the moment you say revival, it means something which existed previously. There cannot be a revival of a fresh. Revival means something was there that is being revived. So therefore, obviously it refers to the so-called cancelled contract, which cancellation is cancelled, and the original agreement is revived.
Yes.
Which original offer
Understood.
was at a point of time when you were a minor.
I
Therefore,
will
we
mention-
relate back to that offer. It's not a fresh offer.
And after that, I am just showing the consequences of the post conduct of this particular. They have accepted money even. They could have easily cancelled me.
Absolutely, that's why we are saying it's not a suppression by you.
Yeah.
They did it with their eyes open.
Yes.
Therefore, they are there. You are entitled to get back the money.
Yes.
Interest will also consider.
Yes.
Will also
This
consider
letter,
because
my lord, actually, that has not been considered in the input order passed by the authority.
did you ask for that in a writ petition? You asked for a registration of a deed.
Yes.
Therefore, that has been dismissed, saying that you are a minor when the contract was entered.
Madam, the carriage of the proceeding, my full submission is that did not consider that
Carriage of the proceeding did not consider.
before the writ court.
Don't
Not
use big
actually-
words. Carriage of proceeding is with the writ petitioner. What would the writ court do?
Writ court only, my lord, only came to a conclusion. That since there is an initial offer,
That is the only
which-
conclusion which is possible.
possible, and there,
Only conclusion which is possible, Mr. Banerjee. Therefore, the writ court came to that.
and I will show, my lord, try to show, my lord, to convince your lordship.
You convince yourself first, Mr. Banerjee, that
My
it was a valid contract.
lord, kindly give me 1 day time, my lord.
No.
So, I can
We have
come
given you 1 day. No further
only
time.
1 day time.
No. You get 1 day time to prefer an SLP.
No.
Because you have stated you are son of an MP and all these
That
things.
is all.
So you have money, so you do that.
I don't
Go
know.
up.
He is not that much.
You will not get any relief here. We are not going to set aside this order because definitely the learned single judge was absolutely right in saying that yes, it was a void contract in there. Contract একটা দিন তো।
No, that is true. That is, I cannot dispute that he is not minor. He was a minor, but
Therefore, since you have not paid for a relief in a writ petition, we cannot go
only
beyond
thing
the.
that-
We cannot go beyond the prayers in the writ petition in
only thing
granting
is that
in granting you some relief.
Oh.
There was no alternative relief even sought for damages or something. We'll give you liberty to approach the civil.
and so for the my lord contract, my lord, I make my submission on this point. If you lordship kindly hear me for a moment,
Yes.
that suppose I am a minor and I did not suppress my age, they came to they offered me with an offer letter of allotment. Thereafter, the agreement was required to be made with me. That agreement has not been made, and thereafter it has been revived. And since even after the revival, they have accepted the penalty interest from me for the delayed payment. I have paid it. Even thereafter, they did not issue any notice to me that your contract, your offer letter will be cancelled. They did not. They directly kindly see the.
It's not dependent on their act.
Yes.
It's not dependent on their act.
In that case, my full submission is that carried be my lord. So for the equitable principle applies here or not, because I did not suppress. Everything was open to them.
There cannot be any equity against the law. We are repeatedly telling you, Mr. Banerjee, from day one. On the previous day, we said thrice. Today, this is the second time we are saying it. There cannot be any equity against the law. They cannot do equity. They cannot waive the law. They don't have the right to.
And so for the my lord, another point I will place, if I lordship permit me, I will place one point that
Yes.
so far the Transfer of Property Act under Section 7 is concerned. Ultimate object was to give a transfer by lease.
Is there any transfer? Your first argument was there is no transfer in the eye of law.
But ultimate object was to get a transfer in my favor.
Ultimate object is not a matter
of this offer that I will execute and
that is the
register.
ultimate object of every agreement for transfer.
So even if a person knowing fully well that I am a minor and I came to a contract, I offer with somebody else, offer has been given to me, and that the authority has assured me that the thing will be looked into, accepted money. Thereafter,
the transfer was not effected, this order was passed. So my submission is that section 7 of the Transfer of Property Act be considered.
কোথায় দাও এতবার
That who are ultimate thing is to get transfer. Offer was not the basic initiation. I am talking about the equitable principle, if it can be by your lordship. That every person competent to contract or entitled to transfer property or authorize or dispose of the transferable property is competent to transfer such property either wholly or in part. So if I am a major, by that time, they could have considered my allotment and give a transfer. By that time, I
starts with every person competent to
contract.
You are not competent to contract. You were not competent to contract.
Every person competent to contract entitled to transfer property or authorized to dispose of the transferred property on his own is competent to transfer such property either wholly or in part.
How does this help you in any manner whatsoever? Every person competent to contract and entitled to transferable property or authorized to dispose of is competent to transfer such property either wholly or in part and either absolutely or conditionally in the circumstances to the extent allowed by the law.
Yes.
So you are not competent to transfer in the first place.
My case is that.
This speaks about not you, of the transferer.
Transferer.
Every person competent to contract and entitled to transferable property is competent to transfer such property. It speaks about the transferor, not the transferee.
Yes. Yes.
Does not help you in any manner whatsoever. How can the Transfer Property Act transgress the Contract Act? It is premised on the Contract Act.
Yes, definitely, my lord. Another judgment, my lord, can be considered by lordships, my lord.
Yes, Mr. Banerjee, let us conclude the arguments. Let us not waste further time on this.
My lord, another submission was that, and kindly consider this judgment if it comes page number 20, paragraph 29 and 30. For a moment, well, I will not take much time. Bosu. Jolly John and all like কাগজ খুঁজে পাবো না। Paragraph 29 and 30 kindly look into. My lord, section 6H of the Transfer of Property Act provides inter alia that no transfer can be made to a person legally disqualified to be transferee. Section 7 of the Transfer of Property Act deals. 6 says that no transfer can be made in a person who is disqualified to be a transferee. Section 7 of the Transfer of Property Act deals with the person competent to transfer. It provides that every person competent to contract is competent to transfer the property to extent and in a manner allowed and prescribed by any law for the time being in force. Under Section 11 of the Indian Contract Act provides as to who are competent to contract. It provides that every person is competent to contract who is of age of the majority and to the law which is subject and who is of sound mind is not disqualified from contracting by any law.
This only says minor can be a transferee. There is no bar in law to transfer a property to a minor. We agree with that fully. But as per your argument, Mr. Banerjee, this was not a transfer. If it was a transfer, your writ petition would not have no cause of action because your writ petition was asking them to execute a registered transfer deed in your favor. Therefore, this was not a transfer. There is no bar in transferring a property to a major. They can still today transfer a property to them. But it's your writ petition, you are claiming your entire right on the basis of their offer and your acceptance by paying the salary. So your premise is your right to get the transfer is that agreement. We don't say for a moment, Mr. Banerjee, that a transferee, a property cannot be transferred to a minor. It definitely can. A minor can be a transferee. You can still today be you could be a transferee when you were a minor. If it was transferred to you, we would have nothing to say. This is not a transfer. This is an agreement on which you are relying on, asking for virtually specific performance. Since they are state, you take advantage of the writ code and very well, we give you that. But you are not entitled to enforce that agreement. That agreement is the only thing which confers a right to get this transfer on you. Otherwise, you have no right. As a matter of right, you cannot have a transfer of a solid property. only on the premise of that offer letter and your acceptance of it.
My lord, in
That agreement, it is being said, it was void because you were a minor at that point of time, not competent.
yes.
This is all we are saying.
See, the
What
thing is that
remains in your matter?
the thing is that the agreement was supposed to be executed. That I try to press before your lordship, that agreement was supposed to be executed.
Lease
As
deed
per
was
the-
supposed to be executed.
No, agreement also. My lord, kindly come to a.
If then you're gone by another stage. There cannot be any enforcement of an agreement to enter into an agreement. That is also more well settled than this.
That is why
An agreement to enter into an agreement, the first agreement is not enforceable in law. There cannot be an agreement to enter into an agreement.
I am asking myself one thing, my lord. I am asking myself that whether, my lord, that is my question. I am asking myself whether the allotment letter with an offer, when it was I have paid the salary as per the terms of the offer, right? Definitely, but not as per there was some delay. They are accepted even. Does the principle of estoppel will come for giving any equitable remedy to the minor at the time when he was a minor? That is my only question I'm asking myself, that even if the
We'll
allotment
answer
of
that. We'll answer that. Yes, Mr. Aduk, what do you have to say?
I have nothing to say about this law, my lord. Already
Money should be
submission before your
money should be returned to them.
Yes, my lord.
Because with your eyes open, and what about interest? Why not interest? Argue on that. You, with your eyes open, entered into a contract with a minor,
My lord,
revived it.
First of all, my learned senior friend has submitted before your lordship suppression of the facts. He has not suppression of this, my lord, facts. My lord, kindly page number 50.
Yes.
Page number 50. Not when we have knowledge, so the appellant was suppression his age, my lord. When, my lord, from for choice of plot, we have knowledge from that day, my lord. The executive engineer designed so and so, Salt Lake, so and so, so and so, so and so, sir. Sir, he wrote a letter. I hereby selected the plot number so and so. I hereby selected. My lord, kindly mark it. I hereby selected the plot number so and so for allotting in my favor. Who has signed this document? Well, after that, my lord, second paragraph, I have seen that the plot selected to me is so and so green so and so, and I am agreeable to abide by these rules and indicated by this government and this original letter of offer. My lord, Sonat Kumar Sao, I have stated my affidavit in opposition. My lord, Sonat Kumar Sao has signed this document. Sonat Kumar Shaw.
Which sounds sure.
My lord, I don't know.
So how is this relevant even?
For myself, he was 5%.
For him,
My lord.
it's written there for Somar Sengupta. Sonat Kumar Sahu has signed for Somar Sengupta.
Yes.
No, but please come to page 45, 45A. Please come there. That is even prior. The first sentence he writes that as I am minor, you have asked me to submit a letter of undertaking for payment of Sano.
My lord, they have not signed, my lord, this document. My lord, kindly, my lord, 45 dated, my lord, 6 March 2017. I don't know, my lord, whether seal here they received or not, my lord.
Cannot raise that point before this court now.
My lord,
Not only that, page 42, come there.
42.
42. Request for their very request for allotment of plot.
My lord.
In that they gave the date of birth. Page 42.
My lord. So,
Item 3 is date of birth. When he applied for the first time, applied to your chief minister then.
Yes. First of all, my lord, 41. 41. They have wrote a letter to the honorable minister in Bengal, my lord, so and so.
Chief minister.
Chief minister. My lord.
Next letter also direct to chief minister.
My lord. And my lord, 45 also, my lord.
This was written by your father.
Father.
Who was an MP.
MP.
For the same political party.
Simple.
And now you have changed. You are a different political party, so you are refusing.
Change, my lord, this resumption was, my lord, cancelled. Before changing, my lord, 2007.
Before regime change,
Yes, in anticipation.
Before,
In
this,
anticipation.
before change,
yes,
somebody else came. The next one came. But they disclose clearly. Page 42 and 45 shows that they disclose clearly their age, and they said that they are a minor. These are part of the record. There is no denial on your part of this.
my lord, we have
Return
denied,
the
my
money.
lord.
Why shouldn't you pay interest to them for this money? You have taken with your eyes open. Why should they be liable? They were given the impression you will give the property to them.
We'll pay the with interest, my lord. I have no problem, my lord. Kindly, my lord, direction.
Why should you have a problem? It's our money which you are paying.
My lord, my lord,
State's money.
because, my lord, our submission is, my lord, this contract is totally, my lord, invalid in eye of law, my lord. And, my lord, we have made submission before this learned single judge, my lord. Our stand is same, my lord. No difference. But here, and, my lord, in my affidavit in opposition, we have clearly stated, my lord, we have knowledge about this, my lord. I have relied on the page 50, my lord, choice of this land. When we came knowledge, he is a minor, my lord. Because, my lord, Sanat Kumar Sao has signed this document.
Where is the impugned order of the learned single judge? Which
Lord,
page? 148.
140. No.
117.
117, my lord. 117. In 48, my lord, this is the minor correction of this order.
Yes.
May I, my lord, just
There's no, we don't want any reply.
no, only one thing.
There's no scope of reply. No clarification is required by us.
I have missed one thing. It's
No new argument. The present challenge has been preferred against an order passed by a learned single judge on September 25, 2020 in WP number 6832 within bracket W of 2008. Who's the next para? The appellant, as a writ petitioner, sought a direction on the respondent authorities for execution of a registered deed of lease in his favor on the strength of an offer letter issued by the respondent authorities for allotment of a plot in Bidhannagar, on the northeastern suburb of Kolkata, which was accepted by the writ petitioner by payment of due salami. For sub next para, the even after the said process of allotment reached an advanced stage, the same was refused by an order dated February 26, 2007 on the ground that the writ petitioner was a minor at the time of entering into the transaction, which was suppressed by the writ petitioner, and as such the transaction was void ab initio and the allotment offer was liable to be cancelled, as there was gross misrepresentation of fact. Who sub next parallel counsel appearing for the appellant submits that there was no suppression at all, since the appellant all along disclosed his age and the fact that he was a minor. Full stop. In particular, reliance is placed by the appellant on the request for allotment dated July 24, 1981, where the date of birth of the appellant was categorically disclosed to be November 21, 1968. Footstep next para. Even subsequently, a letter was written by the appellant to the Deputy Secretary, Government of West Bengal, HD, MD Department, where it was categorically mentioned that the appellant was a minor. Full stop. Next para, it is argued that despite such clear disclosure, the respondent authorities, with their eyes wide open, sought for, demanded salami to be deposited by the appellant, full stop, by a letter of offer of allotment dated October 30, 1981, it was inter alia given out to the appellant that after the salami in full stroke part is deposited, an agreement with the government had to be entered into, accepting all the terms and conditions of the lease in the form to be sent to the appellant separately. Full stop. It was further mentioned that after full payment of all dues, the appellant had to get the lease drawn up, executed, and registered. Full stop. Next para. Thus, it is argued that the allegation of suppression or misrepresentation was incorrect and the transaction could not be called off at the behest of the respondents on such ground. Full stop. It is argued that the learned single judge failed to take into consideration such aspect of the matter. Full stop. Next para, learned counsel for the appellant next argues that although Section 11 of the Contract Act creates a bar in a minor entering into a contract, there is no legal bar in a transfer being effected in favor of a minor. Full stop. In support of such contention, learned counsel cites Neelam Gupta versus Rajendra Kumar Gupta, reported at AIR 2015. AIR Online 2024 SC 678. Full stop. Next para. Learned counsel for the appellant next contends that the allotment letter, the offer of allotment given to the appellant is not a contract and, as such, cannot be said to have been vitiated by operation of Section 11 of the Contract Act. Full stop. Next para. Thirdly, it is argued that the respondent authorities are bound by promissory estoppel, even if not by contract, from resiling from the offer letter initially issued to the appellant, since the appellant acted on the basis of such representation by paying salami and interest for delayed payment of the balance salami. Full stop. Next para. Learned counsel for the appellant cites Khan Gul and another versus Lakha Singh and another, reported at ILR volume 9 within bracket Lahore series, bracket close, where a full bench of the wherein a full bench had observed, inter alia, that in India, the jurisdiction of the courts to require a party at whose instance an instrument has been adjudged to be void to make any compensation to the other party which justice may require has been expressly recognized by the legislature in sections 39 and 41 of the Specific Relief Act. Push up. The discretion of the court in the matter, it was held, seems to be absolutely unfettered. Full stop. They might, in appropriate cases, while adjudging a deed executed by a minor to be void, order refund of the monetary consideration received by him under the contract, and in addition make him restore any other benefit which he had derived therefrom. Full stop. The court further held that there cannot be any distinction on such ground even if the minor is not the plaintiff but a defendant in the proceeding. Push up next para. Thus, it is argued that the order of the learned single judge ought to be set aside and the respondents be directed to execute a regular registered lease deed in favor of the appellant. Push up next para. It is lastly pointed out by learned counsel for the appellant that since the appellant had attained majority when the respondent authorities had given a fresh offer letter in the form of a revival, the bar under section 11 cannot be said to be applicable at all on such count as well. Push up next para. Learned counsel for the state opposes such contention and argues that in view of the appellant being a minor at the relevant point of time, when the initial offer letter was issued, the contract was barred by section 11 of the Contract Act, and as such, there cannot be any scope of implementing the same. For sub next para, upon hearing learned counsel for the parties, we find that the ground of suppression, which was inter alia taken by the respondent authorities for rejection of the allotment in favor of the appellant cannot be sustained. First up, by a specific, in the request for allotment of plot of land itself, dated July 24, 1981, when the appellant was still a minor, it was categorically, the date of birth of the appellant was categorically disclosed to be November 21, 1968. First up, even thereafter, in a subsequent communication to the Deputy Secretary, Government of West Bengal, dated September 24, 1981, the appellant had mentioned that as he was a minor, he had been asked to submit a letter of undertaking for payment of salami. Footstep next para. Hence, at all relevant points of time, the fact of the appellant being a minor was within the knowledge of the respondent authorities. Where is the revival letter, Mr. Banerjee?
105.
Thank you. Next para. Even in the letter of letter of revival of the offer dated December 14, 1988, by when the appellant had attained majority, it was stated by the respondent authorities that the offer was cancelled as per the terms and conditions therein. Footstep, however, upon sympathetic consideration, subsequently the same was revived. Footstep, next para. Thus, the ground of suppression was not available to the respondents at the juncture when the when the allotment, the transaction relating to allotment of the plot in question to the appellant was turned down. Next para, however, we are unable to agree with the contention of the appellant to the extent that the offer in question was void ab initio by operation of section 11 of the Indian Contract Act at the juncture when the offer was accepted by the appellant. First up, when the initial letter, when the initial request for allotment of plot was made, that is on July 24, 1981, the appellant was a minor. First up, since the date of birth of the appellant is November 21, 1968, by simple arithmetic, he attained his majority on November 20, 1986. Footstep, next para. However, the letter of allotment which was initially granted to the appellant was on October 30, 1981, and as such, on the said date, comma, the appellant was still a minor. Full stop. Even subsequently, comma, the appellant deposited salami and thereafter interest on delayed payment of the balance salami, comma, all pursuant to the initial offer letter, which was accepted by the appellant by such payments. Full stop. Next para. By the initial acceptance of the allotment by the respondent authorities on the request of the appellant and the subsequent payment of salami on the offer letter issued by the respondents, comma, at a juncture when the appellant was a minor, comma, the agreement itself was vitiated. Full stop. Next para. The appellant seeks to argue alternatively that the transaction comprised of the offer letter and the payment of salami did not tantamount to a contract within the said expression as used in the Contract Act. Full stop. However, comma, if such argument is to be accepted, comma, the very basis of the cause of action for the writ petition of the appellant goes, comma, since the right of the appellant to get a registered lease deed executed in his favor is entirely based on the contract comprised of the reciprocal promises constituted by the offer letter and the acceptance of the appellant by payment of salami. Full stop. If there is no agreement in the eye of law, comma, there cannot be any right in the first place of the appellant to claim execution of a lease deed in favor of the disputed plot in his favor. Full stop. Next para. Thus, comma, such argument can be discounted at the threshold. Full stop. Next para. However, comma, proceeding on the premise that the said transactions tantamounted to an agreement stroke contract, comma, as held above, comma, the bar under section 11 of the Contract Act comes in and the agreement was void ab initio, comma, irrespective of whether the whether there was any suppression or not by the appellant and or any acceptance on the part of the respondents. For sub next para, it is well settled that there cannot be any estoppel or waiver against the law. Full stop. Since a minor is not competent to enter into a contract under the contemplation of the Indian Contract Act, comma, the agreement was void ab initio. Full stop. Next para. Thus, comma, the secondary argument of promissory estoppel cannot override a bar of law. Full stop. The concept of estoppel emanates from the law of evidence and has crystallized into a doctrine of equity. Full stop. The law lays down that if a promise is made by one party, comma, upon which the other party acts to his detriment, comma, the first party becomes bound by promissory estoppel to perform his part of the contract in favor of the second party, comma, who acted on the promise of the first party. Whose of next para, however, comma, the entire edifice of promissory estoppel is based on equity. Full stop. It is an equally well settled law that equity cannot override a specific legal bar, comma, nor can a legal bar be waived by any of the parties to a contract. Full stop. In the present case, comma, we are looking at an absolute bar under section 11 of the Contract Act, which could not have been overridden by either of the parties. Full stop. Hence, comma, the reliance of the appellant on the principle of promissory estoppel against the law is misplaced at the outset. Full stop. Next para. In view of the above discussions, deal kore liya. Insofar as HON'BLE Supra is concerned, comma, the said judgment does not help the appellant in any manner whatsoever. Full stop. in the said judgment, comma, it was only laid down that where a contract with a minor is set aside, comma, the said the party at whose behest such contract is set aside is liable to pay, may be liable to pay compensation to the other side. Full stop. The said proposition was held to be irrespective of whether the minor is the plaintiff or the defendant in the proceeding. Full stop. Next para. In the present case, comma, compensation was not even sought for by the appellant. Full stop. The appellant elected the remedy of having the void agreement implemented by filing the writ petition asking for a mandamus on the respondents to execute a registered deed of lease in favor of the appellant. Full stop. Hence, comma, the reliance of the appellant on the said judgment cannot be taken note of. Full stop. Insofar as Neelam Gupta Supra is concerned, comma, it was laid down therein that the bar that the bar under Section 11 of the Indian Contract Act, comma, read in conjunction with Section 54 of the Transfer of Property Act, would not come in the way of a transfer of an immovable property in favor of a minor. Full stop. Next para. There is no quarrel with such well-settled proposition. Full stop. Definitely, comma, a property can be transferred in favor of a minor. Full stop. However, comma, in the present case, comma, as admitted by the appellant as well, comma, no transfer had taken effect, but there was only an agreement which is sought to be enforced by the appellant, comma, who was a minor at the relevant point of time, comma, by relying on the said void agreement. Full stop. It is Section 54 of the Transfer Property Act itself provides that a mere agreement to transfer a property does not by itself comprise of a transfer. Full stop. Hence, comma, the proposition laid down in Neelam Gupta's case is also not attracted in the present case. Full stop. An interesting argument has been made by the appellant to the effect that when the offer was revived on December 14, 1988, comma, the appellant had already attained majority, and as such, the said offer should be construed as a fresh offer. Full stop. If so construed, comma, the appellant if so construed, comma, the agreement comprised therein would not be vitiated by Section 11, and the appellant would have a contractual right to have a lease deed executed in his favor. Full stop. Next para. However, comma, we are unable to accept such contention as well. Full stop. The clear language of the communication dated December 14, 1988 to the appellant by the Assistant Secretary to the Government of West Bengal was that as the appellant had failed to pay the balance salami within 3 years from the date of offer of allotment order under reference, comma, the said offer stood cancelled as per terms and conditions contained therein. Full stop. Importantly, comma, immediately thereafter, it is stated that, however, comma, after careful and sympathetic double inverted মধ্যে, consideration of the difficulties of the appellant mentioned in his letter, comma, the Assistant Secretary was directed by order of the governor to say that the governor had been pleased to decide that the offer of allotment under reference would stand revived italic say, on the appellant making payment of the balance salami, italic say, balance salami in prescribed manner and submit receipted challans within 60 days from the date of issue of the letter on the conditions stipulated thereafter. So the use of the two expressions double inverted revived and double inverted balance double inverted close to qualify the said offer unerringly point to the said offer not being a fresh one but merely a continuance, comma, on revival, comma, of the initial offer which was accepted by the appellant, comma, both at a juncture when the appellant was a minor. Full stop. It is a settled proposition of law that if an act is void ab initio, comma, the same cannot, comma, by subsequent ratification, comma, be legalized or regularized. Full stop. In the present case, comma, the said principle is squarely applicable, comma, since the initial contract between the parties was void due to the minority of the appellant, comma, which could not subsequently be revived at a later date when the appellant attained majority, comma, post facto. Full stop. Next para. In view of the above, comma, we are of the clear opinion that the learned single judge acted well within his jurisdiction in dismissing the writ petition of the appellant on the ground that the appellant was a minor at the relevant point of time when the agreement was entered into between the parties. Full stop. Next para. However, comma, since the appellant, since the respondent authorities cannot be permitted to have a windfall gain by being unjustly enriched by the amounts which were deposited by the appellant at various points of time in pursuance of the offer letter, comma, which was issued by the respondent authorities with their eyes wide open, comma, despite full knowledge of the minority of the appellant, comma, the respondents are liable to return the entire amount paid by the appellant to the appellant. Full stop. Next para. Upon a consideration as to whether we should impose interest on such payment, comma, we find that all along, comma, both parties had acted on the premise that the agreement between the parties was enforceable, comma, prior to the order of refusal to act on such agreement, comma, which was challenged in the writ petition. Full stop. Thereafter, comma, till date, comma, the matter has been sub judice, first before the learned single judge and thereafter before this bench. Full stop. Hence, comma, at no point of time could it be said that the right of the appellant to get back the money was crystallized, comma, more so since no prayer, comma, even in the alternative, comma, for refund of the money was made in the writ petition. Full stop. Hence, comma, we do not find any reason to saddle the respondents with interest, comma, since the right of the appellant to get back the money paid as salami, balance salami, interest, comma, etc., accrues stroke ripens only now, comma, upon our passing of this order. Full stop. Next para. Accordingly, comma, in the light of the above observations, comma, we dispose of FMA 728 of 2021 without interfering with the impugned order. Full stop. However, comma, we further direct the respondent authorities to refund the entire amount of salami, comma, interest, comma, balance salami, as well as other monetary amounts accepted, paid by the appellant to the respondents pursuant to the void allotment offer at all points of time to the appellant within 90 days from this date. Full stop. Next para. In the event, in default, comma, the appellant will be entitled to have the said component of our order executed in due course of law. Full stop. Next para. We further make it clear that this court has not entered into the question as to whether the appellant would be entitled to damages at all. Full stop. It will be open to both parties to seek damages against each other on the basis of the cause of action before us, comma, if so entitled in law, comma, before the competent civil court having jurisdiction. Full stop. If such proceeding is initiated by either of the parties, comma, such court shall deal with the same in due process of law and in accordance with law without being unduly influenced by any of the observations made in that regard by us. No address to cost. Is any can pending or no?
Gratefully heard. Well, only one thing that there is mentioned that MD department, it will be UD department, Urban Development Department.
Respondents we have stated. Respondents we have stated. Next.
Grateful. Deeply obliged.
And in this matter, my lord, I'm in a difficult situation. My lord, Mr. Bhattacharya is assisting me. My lord, Mr. Bhattacharya is suffering from fever, my lord. And he
No,
is
Mr.
not-
Dhar, then we'll cancel the Pathar. We'll have to cancel the Pathar. Pathar matters no time. You are there, you are ready in the matter. Please argue the matter. No time.
Kindly excuse me if I cannot, my lord, hand up the judgment's number of copies, my lord.
That's your problem, Mr. Dhar. You should have been ready.
uh,
Even if Mr.
Better,
Bhattacharya is not there, you are appearing in the matter.
uh,
You
he-
know the matter is Pathar.
he
You should have
came
been
to
prepared
my
with your
chamber
independent.
yesterday, my lord, 2
You
days.
should have taken out copies. You knew at least yesterday that he was not ready. So you should have been prepared with the copies of the judgments.
After I coming the court, my lord, he informed me that he is suffering.
Take out copies of the judgments in the meantime. Ask your clerk to do
Hmm.
that. Give him the citations. What is the big fun in not having copies of the judgment?
My lord,
Yes, Mr. Shara, you were arguing or?
I was arguing.
Yes. Please just in a nutshell
Just-
remind us
just.
and then we'll continue.
Bilnanga 2 Panchayat Samiti is the petitioner of your lordship. They have been granted 6 ferries
Oh, that. Yes.
in terms of 2 government circulars dated 7th March 1979 and 22nd of June 1987. All on a sudden on 17th July 2025, district magistrate passed a restraint order restraining the Panchayat Samiti so far the monitoring and controlling of one of the ferryguard, Narkelbari ferryguard, out of 6. In the interim order, 2 provisions of law has been relied on. One is Rule 281 of the Land Reforms Manual and Section 110 of the West Bengal Panchayat Act. So far, this is page 132. I have already placed before Lordship page 132 of the stay application.
Yes.
But first paragraph, if you Lordship kindly see,
Hmm.
it says about Rule 281 of the Panchayat Manual, second paragraph. The subject says, restraint from further settlement of Narkelbari ferryguard by Beladanga to Panchayat Samiti.
Hmm.
Paragraph 1, it has come to the notice of the undersigned that the Narkelbari ferryguard has been settled in favor of so-and-so to Panchayat Samiti. Second paragraph, this act of settlement is irregular and constitutes an overreach of jurisdiction. As per Rule 281 of the West Bengal Land and Land Reforms Manual 1991, it is categorically stated, public ferries and non-public ferries, ferries which have been declared as public ferries under the Bengal Ferries Act 1985,
Panchayat Act.
shall be exclusively under the control of the district magistrate subject to the direction.
Yes. West Bengal
The
Panchayat
second
Act.
paragraph says it is pertinent to emphasize as the statutory use of the shall, which denotes a mandatory provision. Then, moreover, as per section 110 of the
Dao.
Well, I'm reading paragraph 3 of the page 132. Moreover, as per section 110 of the West Bengal Panchayat Act 1973, the management of any ferry may entrust it to a Panchayat Samiti only if such power of delegation by the state government, and that too with the approval of the cabinet. In the absence of such explicit approval, no authority lies within the Panchayat Samiti to undertake such settlement. In the absence of explicit cabinet approval, the said settlement stands in contravention of the prescribed rules of business of the state government. It is therefore directed that the practice of holding tender or entering into settlement for such ferryguards by the Panchayat Samitis must cease forthwith. As such action are in the clear violation of the West Bengal financial rules and may lead to potential losses to the constitutional fund of the state besides amounting to delivering publication. But I have already placed before your lordship so far the Panchayat Act is concerned. If you lordship kindly take the Panchayat Act. 2-3 provision I have shown to your lordship. The first, if your lordship kindly come to section 94. of the Panchayat. The constitution of the Panchayat Samiti.
Yes.
For every block, the state government shall constitute a Panchayat Samiti bearing the name of the block. Now, Your Lordship, kindly come to the sub-rule 4. Subsection 4. Sorry, my lord, subsection 4.
Yes.
Every Panchayat Samiti shall be a body corporate having perpetual succession and a common seal, and shall by its corporate name shew and be sued. So this is a body corporate, local self-government, separate identity. Now, Your Lordship, kindly come to section 110, which has been quoted by the district magistrate in the order included.
Yes.
But state government may place other property under Panchayat Samiti. The state government may, from time to time, with the consent of Panchayat Samiti, place any road, bridge, ferry, channel, building, or other property vested in the state government and situated within the block under the control and management of Panchayat Samiti, subject to such condition as it may specify, provided that the state government may, after considering the views of the Panchayat Samiti, withdraw such control and management to itself, subject to such condition as it may specify. So, at the time of withdrawal, a consent is required from the concerned Panchayat Samiti. Now, Your Lordship, kindly see section 212 of the Panchayat Act.
Yes.
Well, directions by the state government in the discharge of the functions, the Gram Panchayat, the Panchayat Samiti, and the Jila Parishad shall be guided by such instructions or directions as may be given by them by the state government from time to time in conformity with the provisions of this act. Kindly take note of. In conformity with the provisions of Panchayat Act. Now, Your Lordship, I have placed before Your Lordship two government notifications. If you want to kindly take note on previous two occasions. The first one is 7th March 1979. These are the source whereby I have been granted 6 ferry cards. The first one, 7th March 1970.
Yes.
But this is Office of the Board of Revenue, West Bengal. Issued. Addressing to all the collector. Subject, making over of all khas or vested tanks and ferries to the Panchayat institutions. In accordance with the decisions taken by the Cabinet, kindly take note of, Cabinet Subcommittee on Panchayat Institutions. For the transfer of khas or vested tanks, huts, bazars, and ferries to the Panchayat bodies for their control and management, it has been decided by the Board of Revenue, kindly take note of, that the following steps should be taken for the quick and implementation of the decisions. 1. List of khas or vested tanks Gram Panchayat wise in respect of which the lease or settlement with the private individual or fisherman or cooperative society of fisheries, etc. expires on the last date of Chaitra 1985 should be prepared immediately. Now, turn the page. We are concerned about the Panchayat Samiti. Kindly come to Roman 6. In case may any khas or vested tanks whose jurisdiction extends over more than one Gram Panchayat, such khas or vested tanks should be handed over to the Panchayat Samiti. We are concerned about the Panchayat Samiti. If it is fallen 2 Gram Panchayats, then it is Panchayat Samiti. If it is single Panchayat, then it is Panchayat Gram Panchayat. And more than 2 Panchayat Samiti, then Jila Parishad. These are the. Then kindly come to my lord, skip over the second paragraph, paragraph number 8. In respect of vested ferries, Panchayat Samiti wise list of such ferries in respect of which the lease or settlement expires on the last date of Chaitra Sanso should be prepared immediately and such ferries formally handed over to the respective Panchayat Samitis. A complete Panchayat Samiti-wise list of vested ferries whose terms expires on subsequent years should also be prepared immediately, indicating against each the date of expiry of the settlement so that they may hand it over to the concerned Panchayat Samiti on time. The ferries covering more than we are not concerned about the Jila Parishad, kindly turn to 2. A copy of each of the list of khas or vested tanks and ferries of your district referred to 1, 3, 4, 5, 7 and 8 above may kindly be sent to the Board of Revenues as soon as they are prepared for its information and record. The Board of Revenue may also be supplied with a copy of the list of khas or vested tanks and vested ferries which are handed over to the Panchayat bodies on or from 1st Vaishak so and so or subsequent. I have categorically made out a case in my repetition that we have been granted all these 6 Gram Panchayats with effect from 1987. That's the first circular, which has been continued by virtue of the subsequent circular dated 7th March 1979. Now, Your Lordship, one provisions of manual has been provided, placed in the order impugned. If you Lordship kindly take up Panchayat manual, land manual.
Yes.
First, if you Lordship come to the introduction, the first paragraph. It does not say under which provision of law it has been prepared. The West Bengal Land and Land Reforms Appeal. According to me, it is nothing but a executive instructions. Kindly take the title, the first paragraph.
Yes.
This manual may be called the West Bengal Land and Land Reforms Manual. Provisions of this manual shall come into force with effect from 1st January 1992. It is a comprehensive manual and covers more or less the whole spectrum of activities. Kindly take note of officials and functionaries at various levels of land and land reforms administration in West Bengal. Then my next 3 is very important. Principles of procedures. This manual lays down principles and procedures to be followed by officials and functionaries in matters relating to land and land reforms in accordance with the provisions of relevant acts and rules made thereunder. Now, Your Lordship, kindly come to the provisions, or you can say, my Lord, 4. The provisions of these orders, notifications, manuals of the state government or the Board of Revenue West Bengal, which were in force immediately before commencement of this manual, shall stand repealed to the extent they are repugnant to or inconsistent with the provisions of this manual. But savings clause, very important. Notwithstanding the provisions of Rule 4, anything done or any action taken in accordance with the provisions of any manual, kindly take note, order or notification of the state government or the West Bengal Board of Revenue. I have shown to Your Lordship both the notifications, Board of Revenue, West Bengal, on or before the date of coming into force of this manual shall be deemed to have been validly done and taken. My case is that, my Lord, I have been granted all the 6 ferry ghats in terms of 2 circulars, 1973 and 1987. Savings clause says, if anything done.
1970?
1970, 79 and 1982. All are prior to coming into force this manual.
Some given in 79, some in 1987.
No, all have been given in 1979. Subsequently, 87, I have shown to Your Lordship, paragraph, last paragraph. It says, my Lord, it will follow 1979. 1987 says it will follow the procedure which has been laid down in the 1979 notification.
It is given periodically, I mean, annually.
No, all the 6 ferries have been permanently granted to us. We are giving it to the general public through e-auctions.
So why was 1987 required? Because 1979 it was already given to you.
Yes, my Lord, this circular says 1987. I am once again reading paragraph 3. The khas and vested tanks and ferries which were handed over by the collectorate to the Gram Panchayat, Panchayat Samitis, Jila Parishad, as the case may be, in pursuance of the memo dated 7th March 1979. So it is confirmed that it will continue. 87 says it will continue in terms of the previous circular dated 7th March 1979.
You read from where, lastly?
I am reading, my Lord, 1987 circular, last paragraph, paragraph 3.
Oh, the previous. Very. Right.
Last scene, my Lord, the 5th paragraph.
Yes.
Shall continue to be managed by the respective Gram Panchayat, Panchayat Samitis in terms of 7th March. For that reason, I have placed before Lordship the subsequent circular dated 22nd June 1987.
Yes.
And it has been says, my Lord, if you Lordship kindly see the first paragraph, in exercise of the power conferred by Section 13 of the West Bengal State Acquisition Act, West Bengal, and read with Rule 12 of the West Bengal State Acquisition Rules. So invoking.
We'll just come back and take
Yes.
this. We'll start from here. Yes. Oh, one second. একটা এই 11 বার একটা 5 দশমিক একটা এক্সট্রা yes yes
Our specific case is that the land manual is nothing but an executive instruction.
yes
It has no statutory force and no binding effect also, and overriding effect also. I have shown to your lordship, my lord, provision 5 of the land manual also, which says that if anything done, that shall continue. Even
Yes.
we are saying our specific case that this is executive instruction,
Hmm.
even if it is given effect to, which has already been done in 73 or 79 or 87, that cannot be touched even. Now, your lordship, my lord, I shall rely upon only single judgment, our division bench. In this case, what happened? Now, through open auction, fisheries have been handed over to a private party by the state government. The previous leaseholder came before this honorable court saying that at the time of grant, there is a contravention of the land manual. The division bench says this manual has no statutory force, it has no overriding effect, no person can come to say that his legal right has been taken away for contravention of the provisions of the
so
manual.
Mr. Shah, we were also not sure on the very first day we asked you from which act this manual derives force. That is not indicated. It has to be indicated in the preamble of the
At least in the preamble,
always it is done.
in exercise of the power,
Yes.
conferred under
Yes.
so and so.
All statutes.
Not
everything.
all statutes, all.
Even your circular of the the second circular.
Circular says, circular says.
87. That also says in exercise of the power.
Yes, yes. I have never seen a statute which says that without exercising power conferred under section so and so, so and so.
Maybe delegated legislation, but
Yes.
it has to say.
Now I am placing before the judgment of the honorable division bench.
After hearing this, Mr. Dhar will become more unready.
But this is a division bench judgment of our
Who was assisting whom on the last occasion, Mr. Dhar? Who was assisting whom? That is our question. So you are citing his absence for very convenient.
This is more competent so for this part of the.
No, I mean the people who are there today, they were the ones interacting on the last day also.
Well, this is Justice Shishir Kumar Mukherjee and Justice Manusnath Rai. Justice Manusnath Rai delivered the judgment as his lordship there was.
Yes.
Briefly stated the facts. Kindly come to my lord, paragraph 5. May I read my?
Please.
On the question of the citation, sorry.
Yes.
1975 1 CLJ, page 117.
Khalta Fort refugee. On the question of the settlement of the Jheel, in the instant case, we find that such settlement is governed by the West Bengal Government Estate Manual, which deals with the principles, policies, and procedure for cash management of government estate. We find that the term government estate in the said manual is used to mean states under the direct management of the government, whether they are the properties of the government or are the states of the private individuals brought under the direct management of the government. Agreeing with the decision in the case of Doityodhari spill so and the subsequent decision of this court in the case of Lalgola Podda Fishermen Cooperative Society so Supra, we hold that the said state manual only contains executive orders made by the government in respect of the administration of its own properties and cannot be considered as a statutory rules, and as such, orders made or steps taken thereunder are not justiciable under Article 226 of the Constitution of the India. Government can own property and deal with it in any manner which is permissible under the law. If there is any statute which imposes a restriction, or if there are statutory rules which compel a certain procedure to be followed, that is another matter, and government would have to follow it. In the circumstances of the present case, We also hold that the executive order complained of cannot be considered as a statutory rule, and violation, if any, of the same would not give rise to a legal right which can be agitated in an application under Article 22 of the Constitution of India. These are my submissions. Only just concluding my submission, I have already shown to your lordship, section 212 of the Panchayat Act, which with no uncertain terms says Panchayat Samiti shall be governed only under the Panchayat Act, section 212.
Yes.
And so far, my lord, the manual is concerned, although my specific case is that this is nothing but an administrative instruction.
Why did you show us 94.4 to say that it's Panchayat Samiti is not merely an instrumentality of the state in that sense?
Yes.
It's not the state.
Local self-government.
Local
self-government. Separate identity.
It's a body corporate.
Body corporate. Local self-government. Well, these are my submissions.
Absolutely. Yes.
And once again, I'm repeating, my lord, out of 6 ferry cars, only one.
Yes, that we had recorded on the last occasion. We are recording evidence. Out of 6, your 6 ferry cars?
Yes, 6 ferry. My 6
regarding
ferry.
one, it has
this
been
restraint order has been passed. We are running this from 1973, all 6, in respect of only Narkelbari ferry card, this restraint order has been passed.
Narkelbari?
Narkelbari.
Very.
No,
thank you. Yes.
Land reform sector.
Land reform sector.
No, kindly land reform sector. Kindly come to section 52 of the Land Reforms Act. Under chapter 8.
Yes.
One is under chapter 6, that is section 49, which deals with the principles of distribution of lands. And another one is under chapter 8, section 52, that is management of lands.
Yes.
This particular section deals with the management which have been vested to the state, how state is going to manage and control this. Now, all lands to which this act applies shall be deemed to have been held under the state on such terms and conditions as may be prescribed. 2. Any land belonging to the state or land which is at the disposal of the state government or held under the state by virtue of the provisions of West Bengal State Acquisition Act or this act means West Bengal Land Reforms Act, or any other law in force shall, unless the state government otherwise directs by any general or special order, be managed in such manner as may be prescribed by the collector of the district under whose jurisdiction the lands are situated, subject to the control of the state government. Particularly determination of terms and conditions of lease as may be specified in the lease deed, and fixation of annual rent with or without premium. So subsection 2 of section 52 deals with the how the terms and conditions would be controlled by the state government, and time to time notifications been issued. Now, my lord, kindly come to section 60. Rather, I'll place, my lord, I'll come to 60 and 62, both. Power to make rules of the government. The state government may, after previous publication, make rules for carrying out the purposes of this act, and the rules so made shall have effect as if they were incorporated in this act. And then 62, power to state government to give directions. The state government may give such directions not inconsistent with the provisions of this act to any collector, revenue officer, or prescribed authority under this act, as may appear to the state government to be necessary for carrying out the purposes of this act, or any rule made thereunder.
Yes.
Now, my lord, kindly come to Rule 28A of West Bengal Land Reforms Rules of 65.
$65 rules.
Yes.
97 rules. We don't have this. Hello? Thank you.
When my lord was sitting at courtroom number 10, my lord has.
Yes. No, my officers are efficient in that. Whenever something is required, they bring it. Now, which rule?
28A.
Yes.
Management of land and estate belonging to the state government in accordance with subsection 2 of subsection.
This will be the relevant one because the period in question is 7987. So therefore, this is the relevant rule.
Without prejudice to the provisions elsewhere contained in these rules, all lands and all interests therein belonging to the state government shall be managed and shall be deemed to have been managed by the collector of the district and under whose jurisdiction the lands are situated in accordance with the West Bengal Land and Land Reforms Manual 1991. My lord was looking for that whether in the preamble is there anything source of the power. The West Bengal Land and Land Reforms Manual, my lord has got it. That before third bracket there is 2, and at the bottom, my lord will get it substituted by notification number such and such. My lord has got it. Yes, that is in the year 19. Initially the West Bengal Estate Manual 53, then thereafter the Management Manual 1957, and this one is 1991. Published by the Board of Revenue West Bengal, being the rules for the time being in force for the management of government lands and estates, subject to such directions as may by general or special order be issued from time to time by the state government in this behalf, provided that the state government may entrust the management of a land belonging to it in any area to a local body or to an authority constituted by or under any law for the time being in force on such terms and conditions as the state government may specify from time to time. Now, my lord, I'll be relying on 281(3) of the manual. Before that, my lord, I'll place the overriding effect of the manual. And to answer Mr. Taharai's saving clause, my lord, I'll try to, my lord, answer that question as well.
Overriding effect is on previous orders and notifications and manuals.
I say, my lord, this particular savings clause is saving those actions or other things which was done prior to this notification, but as section 52 and section 60 and 62 read with 28A of the rules, time to time government will come up with the different terms and conditions and how government will manage the things, that discretion is exclusively lying with the government, and government has decided that we will come today, these are the norms. Tomorrow, after 10 years down the line, this could be another norms which government might take as a policy.
Rule 5 of the Land Reforms Manual is still there. That has not been amended. Can you retrospectively do something which you could not? You say for the new grants, a new direction can be given. We agree. Government has always the right to reframe its rules and make new directions, definitely. But these are the directions which we are speaking about, and there is no change in Rule 5.
Now let us read 281 and Malad, the 9 power to DLRS to issue instructions. In the manual, the Director of Land Records and Surveys, West Bengal, is authorized to issue technical instructions subject to guidelines, if any, that may be issued by the Board of Revenue from time to time to be followed in technical matters, including preparation on revision of maps, land survey, etc.
That
Then
is
two,
technical instruction.
that is survey. Then two, save as otherwise provided in this manual, the DLRS and surveys, West Bengal may issue such detailed instructions, act and rules. Then 3, registers or forms are not prescribed in any act, rules, and the power of the Board of Revenue to issue instructions. Now, my lord, 9, 10, now my lord, kindly come to 281. Before that, my lord, we'll find chapter 14, 17A, that is settlement of all costs. That is at page, the clause 283A. Now, my lord, kindly come to 281. This is also how to settle the lands, ferries, fisheries, and other Shariati interests under that chapter. Now, my lord, kindly come to 281. Ferries which have been declared as public ferries under the Bengal Ferries Act 1885 shall be exclusively under the control of the district magistrate. Subject to the direction of the commissioner, these are now under the administrative control of the Public Works Department. Other vested and HON'BLE ferries will be governed by sub-rules 2 to 8 of this rule. Then procedure for settlement of ferries should be settled by the district land and land reforms officer by public auction to be held at least 3 months before the date from which the settlement is to have effect. Public auction shall remain restricted among cooperative societies or partnership firms as conceived in Rule 266A. Then 3. Preference should be given for settlement of ferries with local boatmen, then cooperative society or partnership concern formed of local boatman and hereditary patni. If there is only one such cooperative society or partnership concern in the locality, settlement shall be made with such cooperative society or partnership concern on the basis of economic rent to be determined by the collector on the basis of 25% of the average of net income of preceding 3 years, and in such event no tender needs to be invited.
And these have been declared as public ferries.
Yes.
But if there is a conflict between the two, which should prevail?
Well,
Section 110.
I say, my lord,
which would be the special statute in with regard to ferries?
After Bengal Ferries Act, this particular settlement of ferry is dealt with this land management manual. And this land management manual has an overriding effect. Hence, that's why, my lord, I said, my lord, the chapter 17 deals with the settlement of ferries, fisheries, and other Shariati interests. Entire chapter. And this particular manual has an overriding effect. So all other actions which was done under the Panchayat Act, now state has taken a policy decision that these are the ferries have to be controlled by the district collector.
But Mr. Dhar, Rule 281 is a part of the same manual which contains Rule 5, the saving clause. So Rule 281 is obviously subject to its own provision, Rule 5, the saving clause. So therefore, if Rule 5 says previous acts are saved, then wouldn't the operation of Rule 81 be precluded in respect of leases already granted?
I say, my lord, in my humble submission, my lord, when state has taken a decision, policy decision, knowing fully well that these are the lands which initially
Where is
was
the policy
handed over.
decision? We don't see any policy decision here. Policy decision as in?
My lord, at page 132, that was the decision in terms of 281.
Page
Kindly come
please
to
come
page
back.
132 once.
Yeah. Not a policy decision, restraint of a particular ferryguard. Is an executive direction in respect of a particular restraint from further settlement of Narkelberry ferryguard. A policy decision has to be general in nature. Even his other 5 ferryguards are spared.
Well, I would like to show that other ferryguards even.
Yes, but this cannot be a policy decision. It's an individual, the decision regarding an individual, a particular ferryguard. This is an executive direction, not a policy decision.
This particular 7th July 2025 has been issued because of our policy decision, which is not before my lord.
Does not refer to it.
Does not.
So unless it relies on a policy decision, Mr. Dhar, we cannot say the court cannot interfere because it's a policy decision.
Then, my lord, kindly.
Otherwise, it would be a valid argument.
Let us read 2. This act of settlement is irregular and constitutes an overreach of jurisdiction. This page 132.
What is that? Yes.
As per Rule 281 of the West Bengal Land and Land Reforms Manual 1991, it is categorically stated that public ferries and non-public ferries which have been declared as public ferries under the Bengal Ferries Act.
This is not the state. This is not any policy decision of the state at all. The district magistrate does not take policy decisions on behalf of the state. Since when does the district magistrate have started taking policy decisions for the state? We don't understand this reliance of yours on this. The collector himself says that I have the power under this. So therefore, that is irregular. He is not an adjudicating authority. First, secondly, he is not the state.
He is saying he is the empowered to distribute the.
That's his interpretation of Rule 281.
281.
But the Rule 281 itself is subject to Rule 5, saving clause.
Yes.
So then, even if we accept all your other arguments that this overrides, yes, very well. But Rule 5 protects previous actions. It has come in 1991. The moment it protects previous, that goes outside the ambit of Rule 281 as well as anything which is contained here. So this person's reliance on this. This is not a policy. This does not rely even on any policy decision. It relies on a purported his perceived irregularity in violation of Rule 281. He himself is a judge, jury, executioner. He says, I am the collector. I have the power under Rule 281, irregularity in giving. Now, by virtue of this, Mr. Dhar, he is actually, in effect, challenging the state action in giving the ferry to them under the Panchayat Act.
And they could not show that this particular ferryguard was handed over to them. There is nothing they can come up with. Only they want to rely on those 2 notifications, and they have been.
Dhar, your argument falls flat in view of the first sentence of this 17th of July.
Yes.
It is admitted.
Accepted. They have admitted.
The collector has admitted it has come to the notice of undersigned that Narkelberry ferry has been settled in favor of them.
Yes.
Therefore, you are stopped from saying that. You yourself say.
Yes. Till that date, the Panchayat Samiti has been settling that. That does not mean that the particular land after vesting.
We are bothered only with this particular ferryguard.
It's a kind of a case where
If you come up with a policy decision, please go and change this the manual itself. Go and have a change in the manual. Who prevents you? You as in state. But the collector, the district magistrate cannot override the action of the state in settling this in their favor. He admits that it has come to his notice that Narkelberi Ferryঘাট has been settled in favor of them. By whom? The Panchayat Samiti, who is otherwise empowered under the Panchayat Act, and Section 110. Now this under
Act 79 and 87 has been now superseded by 1991 manual.
Act cannot be superseded by any manual. You may say that the Land Reforms Act provisions, but that conflict was there because Land Reforms Act is not a new act. It was there at the relevant 1955, it was there. And Panchayat Act is of which year? 53, 60, 73. Later. So therefore, in the later statute, the legislature was deemed to be aware of the provisions of section those sections in the Land Reforms Act. So despite being aware of Land Reforms Act and the powers given thereunder, this provision is incorporated in respect of specifically ferries. So how do you deal with that?
The overriding effect of 91 manual has come later on.
Manual cannot go beyond the main statute. It derives power from, at best, this Land Reforms Act.
That power has originated from Section 60.
Which act was there?
Yes, Act was there.
When 1973 Act came. And in 1973 Act, Section 110 has been introduced. Specifically. So how do you deal with that?
Well, I'll have to come back on this.
Don't come back. Come back in a different matter. So therefore, otherwise, yes, we can. Two tricky points against you. One is that this what we last said, and the other is a saving clause in the same rule book which contains 281. That is the difficulty you face. Therefore, 281 will be circumscribed by that.
Then, my lord, the maintainability of the writ petition.
Why not? Maintainable?
Regarding, my lord, if I took this point, my lord, the Section 60 and Section 52 of the Land Reforms Act, as well as Section 60 and 28A of the rules, as well as the manual. These all are coming under the specified act as 2R. So whatever adjudication, that adjudication has to take place before the tribunal. Mr. Shahrai might have a very good case, but subject jurisdiction is missing.
But the learned single judge has adjudicated on merits.
Not on merits. Yes. Not on merits. I would not
We'll
say.
just look into that one.
Kindly.
Before parting with you.
Yes.
Page 162 of this.
Page 162.
The petition has been admitted, direction has been given.
Only?
No point has been raised.
No. I said, but even if I do not take the point, Malad, if the court does not have the jurisdiction on the subject, then I can take this point anywhere. Kindly come to 3 and 4. Para 3 and 4. Though in the instant writ petition, the memo dated such and such as floated by the respondent number 4, authority is under challenge at the instance of the writ petitioners. However, it appears to this court that it would be appropriate if the Principal Secretary, Panchayat and Rural Development Department sits with the Principal Secretary, Land and Land Reforms, Refugee Rehabilitation Department for settling the dispute as involved in the instant writ petition across the table. 4. In view of such, the Principal Secretary Panchayat and Rural Development Department and the Principal Secretary Land and Land Reforms and Refugee Rehabilitation Department are directed to hold a joint meeting positively within 15 working days from today, and the minutes of such meeting shall have to be placed before this court by the learned advocate for the respondent state on the adjourned date, that is on November such and such, when the instant matter will be listed under the heading of adjournment.
Without any order of stay, this
Without any order of
without
stay.
any
That
order of
has
stay,
prompted them.
Mr. Dhar, this entire exercise will be rendered infructuous. If you go on
all
sitting
along,
and
my
sitting on the
stand-
table, sitting on the table,
all along my
at the
stand
same time
before,
you give it to someone else.
if my lord recollects, all along my stand before my lords, that we will not settle, we will not take any call till this exercise takes place.
But after that, what happens? If this exercise fails, you will take a call.
Regarding the
Therefore, we have to consider whether a stay should have been granted. The court of its own said that you sit on the table and do these things. You are paying deference to the order of the court. We have no doubt on that. They are also not alleging that you are violating the order of the court or something like that. They are saying that while this process is on, why shouldn't there be a stay? Because a strong prima facie case has been made out, arguable case.
on that score, my lord, this should have been relegated before the tribunal, considering the subject.
Very good. So you place reliance on the provisions of this section, particularly this section 52 of the West Bengal Land Reforms Act, and read in that light, and the reference to
section 60 of the
section
West
60,
Bengal Land
section
Reforms Act
52, 60, 62,
and 28A,
28A, Rule 28A,
which refers about the
refers to
91
manual.
And my lord wanted to see whether this 91 manual,
yes,
is the product of. Now, this is the notification which I could not show the other day.
Give a copy.
This is under section 62. This 91 manual, and these are the latest amendments.
But this was not placed in the writ court also. You were present.
No. On the first day,
this is 6th April 1993.
Yes.
Land manual is of 1991.
That's right. Subsequently, it was notified. And now, kindly have a look to this.
How long will this patchwork happen, Mr. Dhar? This patch up. 1991, you issue the manual.
Yes.
And in 1993, you say
It
that was done.
What is the fact, I cannot.
Post facto.
Post facto. It was ratified, and kindly have a look to this present 12th September 2025's notification.
You have given a copy to them also?
Yes, I have given them.
What does it say?
This is whereas the proposed draft amendment in the West Bengal Land and Land Reforms Manual 1991, hereinafter referred to as the said manual, was published as required by subsection 1 of section 60 of the West Bengal Land Reforms Act. So any amendment to the 91 manual is the product of the section 60 of subsection 1 of the Land Reforms Act. And all other judgments which says this manual is nothing but a government instruction, compilation of government instruction, it has got no statutory flavor. Those judgments have never considered section 60 subsection.
That was a different manual. That was also a different manual, estate acquisition manual. Not
this land reform manual.
That was cited by Mr. Shahara for the proposition in general, not because of this specific manual. Let us hear Mr. Shahara in reply. Yes, Mr. Shahara, what is your reply to these points raised by him?
It's the maintainability point is concerned.
You are not relying. Yes.
Regarding judgments,
you want to cite some judgment? Cite it. Yes. Complete your argument. We asked you that. Those are not with you. Mr. Shah will keep it on the next. At one in an event we'll have short bench. Next Thursday you have difficulty.
My son is coming. That's all.
No,
Subject to lordship
No,
consider.
no, we have nothing to say. Mr. Bhattacharya by then will come and be again fall sick and then we'll keep it then on. It's a part-hard matter. That's why we are.
I
No,
never.
you'll have to. In this matter, reply is required. Very well. Heard learned counsel for the parties. So at this juncture, learned counsel appearing for the respondents seeks an adjournment to enable learned counsel to cite certain judgments. Who's up next para? Learned senior counsel appearing for the appellant submits that he is in some difficulty next Thursday. Since the matters are taken up only on Thursday, these matters are taken up only on Thursdays, let the same be listed next on January 8, 2026, which is the next available working Thursday.
My learned friend has already given an assurance and that has been recorded in the first order, not to take any steps in the matter.
Yes.
A learned senior counsel appearing for the respondents, in his usual fairness, submits that the assurance given by the respondent authorities to the effect that no action shall be taken in the meantime on the basis of the impugned, what is that?
132.
No,
Restraint order.
Impugned.
And they have issued the tender also, my lord, subsequently.
That tender failed.
Impugned.
That also I have mentioned.
Restraint order dated July 17, 2025 and not take any subsequent and not take any further action in pursuance thereof. First.
My lord, I'm getting much. Last next occasion, my learned friend will relay the judgment, then I shall give the reply.
Yes, obviously. Otherwise, no use in.
My lord. Reference to the
I'm deeply obliged.
Thank you.
I'm sorry,
May I request my learned to give the reference?
Yes, yes. Give the references in advance so that it will be easier.
I'm get first.
I am for the appellant, my lord.
Yes.
Wife is the appellant before
You
lord.
have 8 minutes, you can start because we have another bench with I have another bench with Justice Kumar. Short bench, but anyway, wife is the appellant.
My lord.
What are you
Wife is
challenging?
appellant,
Divorce
but-
degree obtained?
Sorry, my lord.
Divorce degree obtained by them or your divorce suit dismissed?
Obtained. I am for the appellant. Divorce granted. Agreed. The wife papered this appeal.
Yes.
Now, my lord, ground taken in the matrimonial suit.
Yes.
That is only cruelty and adultery. The plaintiff.
Only cruelty and adultery. We would be happy with something else. Yes. So not separation, desertion or something.
Decision not taken.
Correct.
Now
Granted on the ground of?
Granted on the ground of irretrievable breakdown of marriage. Both.
Now it's very difficult, yes.
Now, my lord, the point is that
Rakesh Raman has now been considered by Justice Nagaratna.
But consent must be there. When the wife did not give consent and irritable breakdown, if marriage has been
in Rakesh Raman's case, Justice Sudhanshu Dhulia held almost that irritable breakdown of marriage will be included within 13(1)(a). That has been revisited by Justice Nagaratna in an unreported judgment, recent judgment. I forget the name. So there it has been held. There is some doubt as to whether it has been held that 142, whether it is under 142 of the Constitution. Then it will not have a binding.
No.
So therefore, it's in question whether irritable breakdown itself can be incorporated within the cruelty.
If they can prove it, my lord.
You say there was no irritable breakdown at all.
Yes, that is.
It has to be from both sides.
Yes.
Let us see.
But I am going to my relevant portion, that is page 77. Learned judge, after taking into consideration all the aspects, evidences, and others, framed some issues, observations. Page 77, top. These are some admitted position in this
77.
case. It's 77, top.
77. This 77 is something else in our copy. The judgment start from page 69 stated.
69.
Yes, it starts at 69.
69 starts from 69.
Ah, 77 starts with there are some admitted
Yes,
positions.
yes. I'm coming to the core issue, my lord. That is the observation of the learned court.
Issues are prior to that at page 73.
Yes, issues are there. I am not.
Acha, you are relying on these only, page 77.
Observations. This is some admitted position in this case. Number one, the parties are Hindus and the relationship between the parties is husband and wife. Number two, the parties have a son, namely Ashish Shir, who is now aged about 12 years and now residing with the respondent wife. Number three, the parties are living separately from each other since 20th March 2011. Should file in the year 2011. Since then, the next visit between the parties before the court at a time of deposition in this case. The matrimonial home of the respondent wife has been made by the petitioner husband by taking loan from Allahabad Bank, being loan account number so-and-so, Allahabad Bank, Birati branch. Number six, that since marriage, the relationship between the parties was strained, and due to some quarrel in the house, the mother of the petitioner left the matrimonial home of the respondent wife in the year 2003. The owners of the matrimonial home are the petitioner husband and his sister. Number 8, the number of cases are pending amongst the parties, like case under section 125 CRPC, case under section 12 of PWDV Act, and case under section 498, 406 IPC. Criminal appeal as per DV Act regarding the case filed by the mother-in-law of the respondent wife, case under section 12 DV Act between mother-in-law of the respondent wife, case under section 12 DV Act between sister-in-law of the respondent wife, and respondent wife case between the petitioner husband and respondent wife has custody of the minor child. Number 9, the reconciliation of the parties has already failed and there is no chance of reconciliation between the parties. Number 10, both parties were suspecting each other and both parties have tried to assassinate the characters of other. Number 11, at the time of filing of this case, the respondent wife was an employee of Rose Valley. Number 12, the respondent's wife wrote a declaration in a white paper on 5th September 2010, and it appears from the said document, which has been marked as Exhibit B, that the relationship between the parties have totally ruined. Number 13, the marriage between the parties, which took place in 20 January 2002, has been registered on 6th March 2002 before the Hindu marriage register. Number 14, DW2, DW3 are the interested witness and the evidence are totally contradictory. Number 15, there is no evidence before the court that just before 18th March 2011, the parties were lived together as husband and wife, though they were lived together under the same roof. Number 16, though a residential order has been passed by the court in favor of the mother-in-law of the respondent wife, but due to objection and filing of the appeal, the said order has not been complied with and the mother-in-law not residing in a son's house. Number 17, though custody order has been given by the learned additional district judge, third court Barashat, in favor of the respondent petition husband within the full knowledge of the respondent wife, but more than 1 year, the respondent wife did not allow the son of the parties to meet together with a plea that the son is not willing to meet with his father. Number 18, there is no chance between the parties to live together as husband and wife. Number 19, both parties have raised wild allegations against each other and both of them did not prove the allegation of adultery.
They have also alleged adultery against him.
Each other, my lord. And number 20, the elder sister of the respondent wife, namely Srimati Nilima Sarkar, is the common witness in all the cases on behalf of her sister. Thereafter, my lord, some 15 to 20 judgment has been placed by the learned judge. And I'm skipping that, my lord, because it is a settled law. I am not going to say this. Then on page 86 bottom. After observing all the rulings and considering those rulings and my discussion as above, I think there is no chance of reconciliation between the parties. Marriage is beyond repair on account of bitterness created by the acts of the husband or the wife or both, and courts have always taken irretrievable breakdown of marriage as a very weighty circumstances amongst the other necessitating severance of marital tie, and the marriage which is dead for all purposes cannot be revived by the court's verdict if the parties are not willing. It is true that when the reconciliation attempt provided futile, marriage between the parties is dead for all practical purposes, and there is no chance of it being retrieved. Continuance of such marriage would
So only on this ground.
yes, amounts to guilty. Only on this ground, my lord. And but
Are you prepared with Rakesh Raman judgment, Justice Sudhanshu Dhulia?
no, my lord. I'm sorry. I have got a judgment by 2009. They are my
No, no,
Supreme
not
Court says-
2009. Very recent.
Yes, my lord.
There are two judgments. I mean, Rakesh Raman is of 2023 probably or 2024.
But my lord, only one point. Whether the trial
Have you brought those copies?
Right now, it is not better.
You don't get yourself prepared in the appeal. That is the only point involved here. Whether that is a good ground.
But my lord, subject to correction, the trial court has such power under that Article 142 Supreme Court may have that power. But
That is what is to be considered. Those two judgments have to be
But
considered.
apart from that point, my lord, and then the case of the-
So your ground, your contention is on this ground. This is not a ground under the
Lordship,
Hindu
that is the
law.
only point.
Obviously,
That is
obviously.
the only point.
But the your allegations of adultery against each other and court's findings are based on evidence that the marriage has broken between the parties. It's very evident, and the son has also grown.
and the proceedings
No,
of 498 has been disposed of, resulting acquittal. She failed to prove that.
That is another issue. But my lord,
Vital issue. Well,
Acrimony is very clear. When was the marriage? When did the marriage take place?
2002, registered 2003.
And you have been separate from when?
2011.
So now, say for 13 years, you are
living
not
separate.
in touch with each other.
True, but my lord, one point is there. The
that is to be considered.
Sequence of consequence, if it is allowed in future, the boy will be ruined because his her qualification only ages. He has no source of
No,
income.
permanent alimony you can always look into.
And another
even
point,
before the even after, even if we affirm this, then also, but it's a very relevant question whether the trial court, the civil court can grant a divorce at all on this ground only.
that is the
That
point.
is the only question to be considered. You
And-
should have prepared.
And from my lord, I'm sorry, I have not. My lord,
Just search by Rakesh Raman, and that has been Justice Nagaratna in 2025 itself has don't recollect the name. One name is Sharda something. The respondent's name is Sharda something. Justice Nagaratna's judgment, where Rakesh Raman and all those have been considered. Justice Nagaratna's judgment says that following Rakesh Raman, several other judgments have been passed by the Supreme Court under 142. So it does not specifically say that Justice Dhulia's judgment, which is Rakesh Raman, was under 142. But from the tenor of this judgment, you may very well argue that yes, Justice Nagaratna also treated that to be 142 judgment. But there is a paragraph 23 or 25 in Rakesh Raman's judgment, which says if the marriage is irretrievably broken down between the parties, that itself amount to cruelty against each other. This is the language used. Cruelty against each other, which can come within the purview of section 13(1) within bracket small ia of the Hindu Marriage Act. If that be so, then irretrievable breakdown itself becomes a component of cruelty, and cruelty is a valid ground under HM. So you have to go through this. Come prepared on this.
Lordship.
No use carrying on with this today also, because
sorry,
those
my
are the
lord.
two one judgment. Rakesh Raman, you can immediately please search out the other judgment. The second name is Sharda. If you search the internet with Justice Nagaratna's name and irretrievable breakdown, then you'll get it.
Lordship.
Rakesh Raman is Justice Dhulia's judgment. We can give you the citation immediately. I have a very bad memory of numerical memory. I don't have at all. So Rakesh Raman is one of the Justice Dhulia's judgment name is Rakesh Raman versus Kavita, only Kavita.
Yes.
Recent years. So you can find out by that. And that has been dealt with in matrimonial. Thank you.
Yes.
Do you have Justice Nagaratna's judgment subsequent? The name at least. Justice Nagaratna, second name contains Sharda something. There, if you want to rely on this, then go through that also. This has been dealt with there. That may go against you. So come prepared on this. You please try to find that out and give it to them also. Huh? Rinku Bhati. Rinku Bhati versus Sharda something. Sandesh Sharda. Thank you. Please write down Rinku Bhati. Thank you so much. Thank you, sir. This is technology. Thank you so much. So we can appoint him amicus curiae, and it will be his fees will be adjusted from the maintenance. You will pay because his judgment he is having to find out. So you also take note of this Rinku Bhatti's case. Well, heard in part for further hearing on December 18, 2025. Only on that part, argue on that. And Rakesh Rama's case, which paragraph says that 25? You can give us the second last or the third last page. It ends with 13(1)(a) of the Hindu Marriage Act. 23 to 25 within that zone.
It is therefore a ground for dissolution of marriage under section 13(1) of the IE.
That is paragraph number?
That is paragraph number. It starts at paragraph number 16.
No.
Paragraph 20 is in the original judgment.
Oh, no. In the SCC judgment, there are more paragraphs. Very well. Oh, they'll find out. 26. That ends with 13(1)(a) of the Hindu Marriage Act. It shall be included as a ground. Cruelty against each other. The irretrievable breakdown itself operates as cruelty against it. You search out. No, after that then. So after quoting Samar Ghosh. Samar Ghosh was quoted, Naveen Kohli was quoted. 27 then. Paragraph 27. So, complete pattern.
But there has been a long period of
You also go through the judgment in the meantime. Yes, since your client is not in a position to pay the subsistence allowance, we'll direct the legal aid services to pay that.
Your Lordship, we will appreciate, my lord, as per your Lordship's direction, about 7 lakhs I did not get till date. But I cannot make myself survive.
Right,
How
right.
do I
We'll
pay?
record that.
That's the whole problem.
We'll record that. By your order dated, no, the matter has been placed in the list in view of a peculiar predicament. Full stop. In our order dated December 8, 2025, we had made the rule bearing CRC 21 of 2025, absolute, thereby directing the contemner to remain in incarceration for a period of 1 month from that date, subject to requisite subsistence expenses being paid by the present petitioner as per the extant law. Full stop. Next para. However, learned counsel for the petitioner thereafter mentioned the matter and submitted that the petitioner wife is financially indigent and not in a position to even maintain herself properly, since no maintenance has been paid by the respondent husband, which was the very reason for directing imprisonment of the husband. First up, next para, taking into consideration such financial stringency of the appellant, which is obvious, since the direction of imprisonment of the contemner was given for the very reason that the contemner did not pay alimony to the petitioner, appellant in full, we direct the Calcutta High Court Legal Services Authority to arrange for the subsistence allowance being paid on behalf of the appellant in terms of the order dated December 8, 2025. Full stop. The office shall immediately communicate this order to the Calcutta High Court Legal Services Authority to take, which shall take, which shall comply with the same on the basis of such communication. Thank you.
I'm extremely grateful, Lord. I'm
No,
sorry
no.
for bothering your
No,
Lordship.
we are sorry. Actually, we should have taken this into consideration. Went out of my mind.
Extremely.
For item number 6, my lord, I am for the respondent. There was a direction to file a supplementary paper book. That copy has not been served upon me.
Not served.
No, my lord, there may be a misunderstanding. My learned friend says that he has filed it in the department.
Take a copy from the department.
Yes, I will have to take it.
Learned counsel for the respondent submits that he does not have a copy of the supplementary paper book. Accordingly, learned counsel for the respondents is requested to take a copy of the same from the department. The matter is adjourned till December 18, 2025.
এটা এখন আমার কাছে একটা আছে তো ঠিক আছে
None appears for the parties at the time of call. Let the matter go out of the list. List বাইরে করে দিন।
Item number 8.
Item number 7, running.
8 who is appearing.
I sincerely apologize. Item number 7,
Has gone out of the list.
I'm extreme. I tender my unconditional apologies, I was from morning. I was here,
7 দিন।
Kindly take some item number 7.
You owe our grace to Rinku Bayati. Appellant ये कोई paper book दिन।
There was a report.
Take a breath. Report বলছি। Postal cost দিয়ে। Service return में। Ready for hearing stand দিলে কি করে? The respondent is not appearing at any stage.
No, my lord, kindly takes up order dated 29th of August 2022, passed by Justice Shen, my lord.
Order sheet কোথায়? কোথায় order?
29th of August, 2022. Bottom portion, it's right.
Twenty-ninth of August, yes.
Yes, Manoj, kindly sees from the bottom, Manoj, in Can 1 of 2022, Manoj will find
Yes.
their lordships were pleased to record in the second page, under such circumstances, consider the service is complete. Now, even after that, on that very date, my lord kindly sees find at the bottom the cost deposited on such and such, my lord got it, for effecting a service of administrative notice out of time accepted. A further administrative notice was issued. That report was awaited. The report thereafter, it was taken up by another coordinate bench, my lord, who directed the report to be filed. Didn't come up. Thereafter, my lord was pleased to direct the administrative notice to be issued fresh. We filed the cost. Even that report is before your lordship, which has come back as inconclusive. But it remains admitted that recorded that the service has been completed. If my lord so directs, I can start the hearing.
We shall start there. We'll just record an order that way.
Yes.
It appears that by previous orders, administrative notices were directed to be served afresh on the sole respondent, who, as per the office report dated August 19, 2025, no service return had yet been received by the department with regard to such service. Next para, however, learned counsel for the appellant rightly points out that video order dated August 29, 2022 passed in connection with Can 1 of 2022 in respect of the self-same appeal, it was recorded that recorded by a coordinate bench that the report filed by the department showed that administrative notice could not be served upon the respondent as the postal envelope was returned with the endorsement insufficient address. It was further recorded that strangely, the earlier notice sent by the appellant to the same address was served upon the respondent as would appear from the report filed by the postal department and disclosed in the affidavit of service filed in court on that date with regard to earlier service. Under such circumstances, the coordinate bench recorded that it considered that the service was complete. Next para, hence, we find that further insistence of service of administrative notice is redundant, in view of the order dated August 29, 2022, which shows that despite service having been concluded once, the respondent was not represented at any point of time. It is, thus, evident that the respondent is deliberately avoiding service and or appearance before this court. Next para, under such circumstances, the appeal is taken up for hearing ex parte.
Husband petitioner before the trial court, my lord, filed a suit under section 12 in alternate section 13 of the Hindu Marriage Act.
Hindu Marriage Act. Yes.
Now, my lord, the grounds were section 12 with regard to that contravention of section 5, my lord, and section 13, my lord, section 13(1)(3), that is mental disorder. Now, the marriage was solemnized on 10th of March 2010. Thereafter, several erratic behaviors and instances of abnormal activities cropped up, for which the wife was treated to several hospitals by the husband himself. Now, my lord, those are the receipts and those prescriptions have been exhibited. Now, my lord, after that, my lord, 20th of January, that is within 10 months of the date of marriage, on 2011, the family of the respondent took her home. From then, they are separated. Now, my lord, thereafter I filed the suit in 2011 itself. Now, my lord, their written statement, they have made categoric evasive denials of my allegations, but mainly their contention only with regard to alimony in their written statement as well. Well, I shall point it out as we go on, my lord. Thereafter, my lord, in my PW1, which was the husband, the documents were exhibited with regard to the doctor's prescriptions and the doctor's remarks were exhibited. Those documents in DW1, those documents were put forward to the wife. In a categorical questions put forward, she stated, I have seen the documents filed by my husband. I have no objection. Now, my lord, second thing, she has admitted in DW1 that I had informed my learned lawyer regarding the doctor's visits. What the learned lawyer did not incorporate those facts in the written statement. Third, there was a question put forward by the court itself whether you were treated at RG Medical Hospital. Since the contention was of the wife, after 1 year of separation, she filed several complaints before the Gram Panchayat and the police, which culminated into FIR that she was she was pregnant, she was beaten mercilessly, then she was taken to RG Kar, she was treated there for 7 days. Now the question which was put forward by the trial court, whether you were treated or not, she categorically admit I never been to Rajikar Medical College. Now my lord, the judgment although starts at page 91, the actual adjudication, it corroborates the plain written statement, entire PW1, entire PW2, DW1, DW3. From 91, my lord, it actual adjudication starts at page 120.
Yes.
Yes, my lord. Now my whole issues number 3, my lord, got it 20. My lord, may I read, my lord? Now let us see whether the defendant treated the plaintiff with cruelty after their marriage and whether the defendant has been suffering from mental disorder of such kind and to such extent that the plaintiff could not be reasonably expected to live with the defendant. It is a case of the plaintiff that the defendant was suffering from mental illness from her childhood. The parents of the defendant gave marriage of defendant with the plaintiff by suppressing mental illness of the defendant. On 2nd of September 2010, the defendant assaulted the plaintiff with a bamboo stick, and on 8th of September 2010, defendant tried to stab the plaintiff with a knife. But the family members of the plaintiff somehow restrained the defendant from committing such an act. But the plaintiff has not examined any independent witness, adjacent neighbor, who witnessed the said incident to prove the said act. This is one of the grounds on which my suit was dismissed. Now, my lord, now, my lord, kindly comes to, may I read the entirety or my lord? Or the relevant portion which I'm
read from here on.
Very well, my lord. Plaintiff has further stated that on 13th of August 2010, he took the defendant to Baduria Department of Health and Family Welfare, Government of West Bengal. But the said health center referred the defendant to Bongaon Hospital. On 14th of September 2010, he took the defendant to Bongaon Hospital, and Bongaon Hospital treated the defendant. And lastly, on 10th of October 2010, Bongaon Hospital referred the defendant to a psychiatrist of Barasat District Hospital for treatment. On 13th of October 2010, the plaintiff took the defendant to Barasat District Hospital for treatment, and the said hospital wrote down the terms as mental illness such as depression. Barasat Hospital referred the defendant to Medical College and Hospital in Kolkata. On 23rd of October 2010, the plaintiff took the defendant to Medical College and Hospital, Kolkata, where the doctor wrote down descriptions of the mental illness of the defendant as aggressive and sleeplessness, etc. The plaintiff, thereafter, the plaintiff and his family members took the defendant to Pavlov Hospital on 17th of January 2011. Said Pavlov Hospital also wrote down the description of mental illness of the defendant as aggressive. He, in his cross-examination, has stated that there is no doctor in his family. On 13th of September 2010, he took the defendant to doctor for her medical examination for the first time. He has filed Exhibit 9 regarding the medical treatment. As per para 6C of his written examination in chief, his family members means his niece, Orpita Kabashi, and his mother, Joshoda Goldar. He has not filed any document regarding the medical treatment of his niece, Orpita Kabashi, and his mother, Joshoda Goldar. PW2 Gopinath Haldar, that is the father of the Gopinath Goldar, has stated that on 2nd of September 2010, the defendant assaulted his son, that is the plaintiff, with a bamboo stick, and again on 8th of September 2010, defendant tried to stab his son with a knife, but PW2 and his family members somehow restrained the defendant from doing such an act. PW2 in his cross-examination has stated that he did not lodge any complaint over the said incident of assault by Sonali Goldar to his son with a bamboo on 2nd of September 2010. His son was not medically treated by any doctor for that assault. They also did not lodge any complaint over the incident which took place on 8th of September. That is when Sonali Goldar tried to stab his son, PW2 and other members, and his family with a knife. The female members of adjoining houses were present there, but he could not say the names of the said female members of adjoining houses. On 8th of September 2010, PW2 was present in their house, and at the time of female members, the female members of the adjoining house were also present there. Sonali Goldar used to sleep at her dwelling room at a time unusually, but he did not enter into the dwelling room of Sonali Goldar to see whether she was sleeping in her dwelling room or not. Both PW1 and PW2 have stated that they took the defendant to different doctors and hospitals for her medical examination and treatment in respect of mental illness. But the plaintiff has not examined any doctor to prove the said medical examination and treatment of the defendant. The plaintiff ought to have examined the doctors to prove the defendant was examined and treated by them for the mental illness of the defendant. The plaintiff has stated in paragraph 10 of the plaint that the plaintiff and his family members took the defendant to Pavlov Hospital on 17th of January 2011 for a treatment. Plaintiff has exhibited OPD ticket number to OPD ticket of Calcutta Pavlov Hospital being registration number such and such dated 17th of February in the name of Sonali Goldar as Exhibit 1. Plaintiff did not exhibit any document of the Calcutta Pavlov Hospital to prove Sonali Goldar was treated medically at Pavlov Hospital on 17th of January. Exhibit 1 further shows that Dr. Bishwajit De used to examine the patients in Calcutta Pavlov Hospital on Fridays and Saturdays. It reveals from the English calendar of 2011 that on 17th of February 2011 was Thursday, but not Friday and Saturday. But it appears from the OPD ticket, Thursday was not the visiting day of Dr. Bishwajit De. Considering the Exhibit 1 and Para 10 of the plan, it can be said the plaintiff failed to prove that on 17th of January 2011, Sonali Goldar was examined in Pavlov Hospital. These are the grounds of my dismissal of the suit. There, the learned judge's grounds. Now, my lord, kindly comes to the DW1, Sonali Goldar, that is the wife. The cross-examination starts at page 73.
Yes.
Now, my lord, kindly turns it over for one page. My lord, from the top, 10th line, once I became pregnant.
Yes.
Once I became pregnant after my marriage, I will not be able to file the said documents as the said documents were lying in my matrimonial house. I was medically treated at Arjikor Medical Hospital. I shall not bring the documents from Arjikor Medical Hospital by filing an application. Not a fact that I was not medically treated at Arjikor Medical College and Hospital. Not a fact that I was not medically treated in relation to my pregnancy. I have seen the documents which have been filed by my husband in this suit. I do not have any objection against the said documents. This is the first. Now, my lord, not a fact. May I read? Continue, my lord.
Relevant questions.
My lord, on the next page, second line, I cannot say the present health condition of my mother-in-law. Second line from the top.
Yes.
I cannot say the present health condition of my mother-in-law as I have been living at my father's house. My father-in-law and mother-in-law were physically fit while I was living at my matrimonial house. My mother-in-law used to perform all domestic works. Now the question put forward by the learned court. Could you tell me the dates when you visited Arjikor Medical College and Hospital and Barasat Hospital? I never visited Arjikor Medical College and Barasat.
How is this relevant? Even
now,
this is pregnancy, and she says
no, she lodged a complaint before the local panchayat pradhan, and a FIR has been registered against me after 1 year after filing of the suit. 1 year of filing of the suit. She claimed then that she was pregnant and she was mercilessly beaten. I shall point out the exhibits, my lord. My lord, very well, my lord, I shall point out the exhibit. My lord, 156, that is the exhibit B. That is the FIR. It is still pending. They are not pursuing with the criminal proceedings. I am 157 is the exhibit copy of the complaint, my lord. In Bengali, may I read from the bottom 2 lines? I'll read, my lord. আমার শরীর ভীষণ খারাপ দেখে ডাক্তারবাবু আমাকে আরজিকর হাসপাতালে পাঠিয়ে দেয়, সেখানে আমার চিকিৎসা হওয়ার পর আমি বাড়ি ফিরি। দ্যাট ইজ ফ্রম দ্য বটম, my lord, the 4th and 5th lines. Now, I would argue that these conditions would tantamount to cruelty because she has admitted, she has absolutely destroyed her own case in the suit. She has admitted, she has filed these complaints against me after filing of the suit. Now she has admitted she has never been treated there. This is the first. And the second argument, my lord, she has categorical admission with regard to the documents that been put forward by in the exhibits by the husband. She admits she has seen those documents. And she admits she has no objection towards them. No, my lord, another thing, my lord, these visits to the doctors were admitted by her to her learned advocate. I am pointing that out, my lord. Page 77, that is the continuation of the DW1. Now, married. I have been summoned in respect of this suit, but I cannot recollect the exact date of receipt of summons. After receiving the summons, I communicated to my learned advocate. I narrated true facts to my learned advocate. I stated to my advocate that I was taken to doctor and the name of the person who brought me to the doctor. My husband, sister-in-law, father-in-law, and co-villagers brought me to doctor for my medical examination. I also narrated the date of my date to my advocate when I was taken to the doctor. I told my advocate about the numbers of the date of my medical treatment to my learned advocate. The entire written statement does not bear a single sentence with regard to this. This was disclosed. Even this is an admission with regard to the fact she was treated for her medical.
This does not say regarding psychological, this is psychiatric treatment, but this
these
may
are
be regarding the Arjikor incident she alleged.
But she admits in her DW1 that she has never been treated. One a question put forward by the court itself.
That is there, but this does not necessarily mean that this was that medical treatment.
Very well, she has seen the exhibit with regard to those questions were not put forward by the put forward before the DW1 that she has seen the documents. She has no objection.
Those are there.
Those are there. Now, my lord, court proceeds on a fact-finding mission. My lord, the entire judgment, the two pages have been actual discussions of actual adjudication rather of my case. That says only with regard to the fact that I have not adduced any evidence with regard to the doctors who has prescribed. Now, since the document, I argue, my lord, since the documents have been admitted, there was no necessity of doctors to be exhibited first. And the second thing, my lord, I did not put forward any depositions of the local villagers or the neighbors. Now, my lord, my father, PW2, has deposed and corroborated that incidents which took place, my lord, on 2nd of September and 10th of September. Now, my lord kindly considers one thing since 2011, my lord, the separation till date, there is no chance, they have not, the parties have not come to a solution with regard to their matrimonial matrimonial life. They're still separated.
No child.
No child. Within 10 months, she was taken back, my lord. Now, my lord.
No, she was taken back
by her parents.
Marriage was on 10th of October.
No, 10th of March.
10th of March. Yes, right.
And the separation, she was taken on 20th of January. Now, my lord, unless court below does not, unless trial court does not go into the deposition of the DW1 or the PW1, the admitted documents of the exhibits, does not consider the evidentiary value of either of those exhibits. She only goes through two things, that since I have not caused any deposition to be put forward before the court by a doctor, and the second thing, the one of the dates of the on which she visited, the wife was taken to the Pavlov hospital, was not a day when the doctor who admittedly treated her was visiting there. Those are the only two grounds under which my suit has been dismissed. I would argue, since there is an admission with regard to the documents put forward by me, there was no necessity to prove those documents beyond any other reasonable doubt. The court did not consider, did not at all. The court entire DW1 was quoted in the judgment. Entire DW1, DW2, everything, but they did not consider at all the depositions given by the DW1.
What is a written statement? What it is?
I'm coming to
in the written
15,
statement,
page 15.
about the Arjikor incident?
No.
Not stated at all?
No. Page 15, my lord, kindly comes. It started, its denial, then it's
In her evidence, she speaks about the Arjikar incident.
she initially does, then she says, I was never treated there.
Where
By-
does she say that she was treated in her evidence?
Yes, my lord. It is DW1, which is cross-examination, starts at page 73 and 74, my lord, from the 10th line from the top. Once I became pregnant.
Examination chief is only this. No, if she filed an affidavit of examination,
She did. Yes, my lord. This came forward in the written cross.
In her examination chief, she did not allege anything regarding this Arjikar incident.
No.
So how was it exhibited?
She has filed complaints.
Complaint must have been exhibited. It is
A
exhibited.
complaint has been exhibited. A complaint entails a
When was that marked as exhibit?
My lord.
How was it marked as exhibit? You exhibited those documents.
Copy of complaint is marked at exhibit A, my lord, page 73, examination in chief of DW1.
This is that complaint.
No, this is a complaint.
But we saw exhibit B.
Yes, my lord, that is the complaint, page 154 to the Pradhan.
না সেটা চাইছি না উল্টোটা চাইছি অ্যালিগেশনটা এলো কোত্থেকে মেডিকেলি ট্রিট করার তো একটা কনটেক্সটে দেখতে হবে কি কনটেক্সট ওর অ্যালিগেশনটা দেখতে হবে যে কি কনটেক্সট ও ওখানে বলছেন এবার ভিজিটেড আরজিকর না না আরজিকর তো প্রেগনেন্সির ব্যাপার বলছি কিন্তু যে পিটিএ ওখানে পাঠিয়েছে সেটা কোথায় বলছে সেটা তো ক্রসে বলবে ও নিজের ইন্ডিপেন্ডেন্ট অ্যালিগেশন কোথায় Where is her allegation that you tortured her and that's why she was treated?
Page 154, exhibit A. And the written statement, my lord.
No, exhibit B, how was exhibit? We saw
No,
one
now I
exhibit
find
B.
from the chief, there was no exhibit B. I have to find out from the trial court records, my lord, whether there is at all there or not. My lord, from the written statement.
Okay. Trial court records একবার দিন ওনাকে You take your time, you just try to check up.
Yes, my lord.
ক্রসে হাজবেন্ড করেনি তো ক্রসে করিয়ে করে নিয়ে থাকতে হয় ক্রসে অনেক সময় ডকুমেন্ট টেন্ডার করে এক্সিকিউটিভ বিয়ে হয় For herself, the wife only.
No, my lord, her father did.
Father also very well. তাহলে father একটা দেখি father
DW2.
father করলো কিনা দেখিনি father করেছে নিশ্চয়ই yes her father approved the document
I tender my apologies.
so page 84
yes Now, even the DW2, there is an admission with regard to the fact. I'm not insinuating anything, my lord. He admits that within 1 month of the date of first visit of the bridegroom party, the marriage was settled. The marriage was rather completed in a haste, and that was pleaded in some not in a happy manner. But
where does it say?
Page 85, DW2. From the third line from the top, within 1 month.
No, he also says we entertained them, page 84.
Yes.
I narrated everything about my daughter to them. Narrated everything about my daughter. I also told them that my daughter Sonali Gundar was able-bodied. Able-bodied. কি বলেছে
within one
না ইয়েতেও বলেছে এফিডেভিট অর্ডার 18
It comes to the written statement,
Hmm.
page 22 onwards. Before that, there were denials of my divorce petition. Page 22. There's the first page, para 10 is with regard to order 32 rule 15 that the suit is not maintainable since I have alleged that such and such. Thereafter, my lord, the summons with regard to summons. Thereafter, financial stringency, para 12, my lord will find it is to be mentioned that the respondent has no financial capacity. This is thereafter, my lord will also find para 13 is with regard to financial stringency. Thereafter, admission with regard to the marriage, para 14. Para 15, there's a demand of 25,000. There's the para 16, dowry pressure. Thereafter, my lord, para 17, again financial stringency. Para 18, there again maintenance of claims, financial stringency. There's nothing put forward in the written statement. She tried to make out a case during her depositions that she was treated to Arjikar Medical College, College and Hospital, on the basis of which she lodged a complaint before the Pradhan. She lodged a complaint before which was registered, police station, which was registered as an FIR. She tried to somehow corroborate that, because the written statement, my lord will find after 1 year of the institution of the suit, these complaints came up. Not immediately. Now, my lord will find the date. Suit was filed in 2011. The complaints exhibit A and B is of 24th of July 2012 and 11th of August 2012. Exhibit A and Exhibit B respectively. Now, she somehow tried to corroborate those facts in a deposition, but when a specific question was put forward by the presiding officer, she rather buckled and said that I was never treated to the Arjikar. Now, these allegations, these baseless allegations made before the Panchayat, who is a local administrative and a police authority for which I'm still being persecuted under a 498 proceedings, does that not tantamount to mental cruelty? These were not considered. It's not that I'm making out these case out of after what has happened with the divorce, but these evidences came up during the depositions and ought to have been looked at by the learned trial judge. But there's no single word used in the as regards the deposition of the DW1. What has transpired therefrom? Even the judgment says with regard to the admission, but I suppose it is only may I just rely on a these are the two. Para 17, my lord. There is no straitjacket formula to apply for mental cruelty. And this was taken to the Supreme Court. It was affirmed, my lord. It was Madras. May I read, my lord? There is no straitjacket formula to apply for mental cruelty.
This is very well settled.
Yes.
Every judgment on cruelty of the Supreme Court also
Yes.
says that. Depends on the
She does
particular.
not prosecute the proceedings as well. It's still pending. I have.
What other judgment?
No, other judgment fell from your lordship. This is not Justice Nagaratna's judgment. This is
That should also be there. Because that goes against.
Yes, my lord, I have it in my device, but this is. No, these are my lord. I'm helped by my these are the.
Very well. Thank you. 8 point something.
Para 27 of the 2023 judgment, my lord. May I read?
No, we know that.
It's in the Supreme Court's original judgment format. There are not many paragraphs. This has been SCC. These are my sum and substance of my argument. And my lord, another thing which was pointed out in the Nagarasi's Nagaratna's judgment as well. I understand that the argument would follow into 142(1), but since there is no child, the parties are only affected by the decree, and it ought to have been construed somehow sympathetically.
If this is challenge, our judgment is challenged, it will go before the Supreme Court, which has 142. So no difficulty on that. The present appeal, despite আচ্ছা প্রথম পোর্শনটা ওকে দিয়েছি একজন কাকে, প্রথম পোর্শনটা ডিক্টেট করে দিয়েছি অলরেডি এই অর্ডারে তোমাকে, তারপর থেকে the present appeal arises out of the dismissal of the appellant's suit for declaration of the marriage between the parties to be a nullity under section 12 read with section 5 of the Hindu Marriage Act 1955 within bracket HMA bracket closed, comma alternatively divorce on the ground of cruelty under section 13 within bracket 1 within bracket small ia bracket close of the HMA. So take your seat, Mr. Next para. Both sides led evidence on behalf of the appellant husband, on behalf of the plaintiff stroke appellant stroke husband, comma, the appellant himself as well as his father adduced evidence, comma, respectively as PW1 and PW2, whereas on behalf of the respondent wife, comma, the wife deposed as DW1 and who was DW2?
Father of the wife.
And the father of the wife deposed as DW2. Next para. The learned trial judge, comma, after narrating the respective cases of the parties, comma, dismissed the suit primarily on the grounds that as per the allegation of the plaintiff stroke appellant, comma, the respondent wife was treated for her mental ailment in the Pavlov Hospital. However, comma, it appeared from the OPD within bracket outdoor patient department bracket close ticket of the said hospital, comma, marked as exhibit 1, comma, that Thursday, comma, on which the visit allegedly took place, comma, was not a visiting day of the treating doctor, comma, being Dr. Biswajit De, DEY. Next para, the learned trial judge also observed that the evidence of the husband and his father were not corroborated by the neighbors or the local people, and that the names of the female members of adjoining houses, comma, who were present on the alleged occasions of attempted assault on the husband by the wife, comma, were not cited as witnesses. Next para. The learned trial judge went on to observe that the plaintiff has to prove his case by standing on his own leg, comma, whereas the plaintiff stroke appellant has failed to do so. Next para. Learned counsel for the appellant argues that the learned trial judge, comma, although narrating all the evidence, comma, did not advert to the specific admissions of the wife in her cross-examination. Next para. Learned counsel takes us through the cross-examination of the wife, comma, particularly where she had stated that she was medically treated at the RG Kor Medical College and Hospital, but shall not bring documents from the said hospital by filing any application in the suit. More importantly, comma, in her cross-examination, comma, the defendant stroke respondent stroke DW1 admitted that she had seen the documents which had been filed by the plaintiff husband and did not have any objection against the said documents. The said documents, comma, inter alia, comma, included medical papers indicating the treatment of the defendant wife in different hospitals, in respect of her psychiatric problems. For sub next para, the the wife, as DW1, in her cross examination, further crucially admitted that she had never visited RG Kar Medical College and Barasat District Hospital for her treatment. Fussa, the said admission was contrary to the specific allegation made by the wife as well as her father, as DW2, to the effect that she was tortured during pregnancy and for such purpose was taken to the medical college and to the RG Kar Medical College and Hospital. Fussa, DW2, the father of the respondent wife also furnished certified copies of Caesar list and first information report as well as the complaint from which the same arose, which documents were marked as exhibits, alleging that torture was meted out to the respondent wife during her pregnancy, which was the cause of her being taken to the RG Kar hospital. For sub next para, it is argued that the said allegation did not find place in the written statement and, moreover, was rebutted by the wife herself in her cross-examination by admitting that she never visited RG Kar Medical College. Push up, it is argued that in view of the premise of the said allegation being demolished by the wife stroke DW1 herself, the said baseless and false allegation against the husband itself tantamounted to cruelty. For sub next para, learned counsel also relies on the documents, the medical papers exhibited by the husband, which were discarded by the learned trial judge on the ground that the concerned doctors were not brought as witnesses, by relying on the admission of the wife that she did not have any objection to the documents submitted by the husband. From the said medical papers, it is argued that it is evident that the wife was consistently being treated for psychiatric problems. Next para, learned counsel cites a judgment of a learned single judge of the Madras High Court in the matter of A Subramanian versus Amuta, AMUTHA, reported at 2018 SCC Online MAD 14222, for the proposition that there is no straitjacket formula to apply for mental cruelty and each case depends on its own facts and must be judged on such facts. Who's the next para? Learned counsel also cites Rakesh Raman versus Kavita, reported at 2023-17 SCC 433, for the proposition that if the marriage between the parties have broken down irretrievably, the same itself tantamounts to cruelty by both parties to each other and comes within the ambit of section 13 within bracket 1 within bracket small ia of the HMA. For sub next para, learned counsel, in usual fairness, also cites an unreported judgment of the Supreme Court in the matter of Rinku Baheti, RINKU versus Sandesh Sharda, SHARDA, where the judgment in Rakesh Raman was considered and the Honorable Supreme Court observed that in various cases the said court had granted divorce decrees on the ground of irretrievable breakdown of marriage, but under Article 142 of the Constitution of India. However, it is argued that even in Rinku Baheti Supra, the Honorable Supreme Court did not deviate from the ratio laid down in Rakesh Raman Supra. Next para, learned counsel lastly submits that since admittedly the respondent wife was taken away by her family on January 20, 2011, that is within a few months after the marriage took place on March 10, 2010, and the parties have never lived together ever since, it is evident from the facts of the case that the marriage between the parties has irretrievably broken down. Full stop. Next para. Thus, comma, relying on Rakesh Raman Supra, comma, learned counsel submits that divorce decree ought to be granted by this court. Full stop. Next para. Upon a perusal of the materials on record, comma, we find certain unique features in this case. Full stop. Next para. First, comma, the written statement of the wife did not contain any specific allegation against the plaintiff husband with regard to any torture being meted out to her during her pregnancy, comma, for which she had to be taken to the Arjikor Medical College and Hospital. Such allegation, comma, for the first time, comma, came up in the evidence, comma, more specifically in the evidence of DW2, comma, the father of the respondent wife, comma, who also alleged, who also exhibited documents to show that complaints were lodged with the Panchayat authority as well as the police on the basis of such alleged torture. Full stop. Next para. However, comma, from the written statement of the wife, comma, we find merely cursory mention of torture being started upon the respondent wife on the ground that she was forced to bring more money in cash, comma, after a previous pressure being put on the respondent wife for a sum of rupees 25,000 in cash, comma, gold ornaments, comma, etc. Push up, however, comma, such allegations were not specifically corroborated in the respondent wife's evidence. Full stop. Next para. From the narrative recorded in the impugned judgment itself, comma, we find that the wife was being consistently taken for medical treatment to various hospitals. Full stop. Next para. For example, comma, on September 14, 2010, comma, the plaintiff husband took the defendant wife to the Bongaon hospital, which treated the defendant stroke respondent. And lastly, on October 12, 2010, comma, it referred the defendant to a psychiatrist of the Barasat District Hospital for treatment, comma, where she was taken on October 13, 2010 for her treatment. First of the said hospital uh, wrote down the mental illness as depression. Single depression. First up. Thereafter, the Barasat Hospital apparently referred the defendant respondent to the Medical College and Hospital at Calcutta, where in the description of the mental illness of the defendant, comma, the terms double inverted aggressive, double inverted close, and double inverted sleeplessness, double inverted close, were written. Full stop. Also, comma, the Pavlov Hospital on January 17, 2011, comma, wrote down the description of mental illness as aggressive, double inverted মধ্যে, full stop. Next para. Although the learned trial judge has discarded the evidence of such treatment on the ground, by choosing specifically the documents of the Pavlov Hospital on the ground that the doctor regularly treating the defendant stroke respondent was not visiting on the relevant date, comma, it may very well be that on a particular date, comma, the doctor usually treating the respondent was not there, but the respondent was treated all the same by some other doctor. Full stop. Be that as it may, comma, even without going into such issue, comma, what comes out from the documents exhibited by the husband is that the wife was being regularly treated for her psychiatric problems and was diagnosed to have aggression. Full stop. Next para. The documents produced by the husband have not been objected to categorically by the defendant respondent wife, who stated specifically in her cross-examination, double inverted, I do not have any objection against the said documents, double inverted close, after having stated that she had seen the documents filed by her husband. Full stop. Next para. Taken in conjunction, comma, the documentary evidence of the husband, comma, coupled with the admission of the wife in her cross-examination, comma, corroborates the veracity of such medical documents, comma, at least to show that the wife was having some psychiatric issues, comma, including aggression. Full stop. The said ingredient of aggression was also corroborated both by PW1, comma, the appellant, as well as his father, the PW2, by stating about two specific incidents of cruelty meted out by the wife against the appellant. For sub next para, on September 2, 2010, comma, the defendant allegedly assaulted the plaintiff husband with a bamboo stick, and on September 8, 2010, comma, the defendant wife tried to stab the plaintiff with a knife. Full stop. Next para, the learned trial judge uh, did not lend much credence to such allegations on twofold grounds, comma, first that there was no corroborative evidence by the neighbors, and secondly, comma, that the husband or his family did not lodge any complaint before any authority or proved that he was medically treated. For sub next para, however, comma, the mere factum of attempted assault by the wife and an attempt to stab the plaintiff with a knife or with a bamboo stick does not necessarily entail that an injury to such an extent would be suffered by the husband, comma, which would require medical intervention worth the name, comma, particularly in view of the specific corroborative evidence of PW1 and PW2 that due to intervention of the family members of the husband, comma, the said attempts did not reach culmination by seriously injuring the husband. For sub next para, such acts of cruelty have not been dispelled in evidence by the respondent wife. Full stop. Rather, comma, it is not understandable as to why the corroborative evidence of PW1 and PW2 has been disbelieved by the learned trial judge without any rebuttal evidence specifically coming from the wife's side. For some next para, it is well known, it is common knowledge that what happens within the precincts of a particular domestic household might not reach the uh, entire neighborhood, comma, sufficient to rope in other neighbors as witnesses to corroborate such incidents. Full stop. Next para. That apart, comma, the the fact that PW2 was the father of the plaintiff does not ipso facto disqualify PW2 as a relevant witness, comma, if his witness remains unshaken in cross-examination, which is the case in the present LIS. Full stop. Next para. Read in conjunction with the above, comma, we also cannot overlook the fact that categorical allegations were made by DW2 in his evidence as well as the wife, comma, tangentially in her cross-examination, to the effect that the husband stroke plaintiff had assaulted the wife with kicks and blows to such an extent that she had to be taken for treatment to the RG Kar Medical College and Hospital. Full stop. However, comma, not a single document was furnished from the side of the defendant stroke respondent to corroborate her visit and treatment on such occasion before the RG Kar Medical College and Hospital. Full stop. On the contrary, comma, such allegations are demolished by the wife, comma, DW1, comma, herself in her cross-examination when she stated that she never visited RG Kar Medical College and Hospital. Full stop. Next para. Thus, comma, such allegations made in the evidence beyond the pleadings, although otherwise cannot be taken as gospel truth, comma, go on to comprise elements of cruelty meted out by the respondent wife against the husband by making false and baseless allegations. First up, although serious allegations were leveled against the husband regarding him having assaulted his wife mercilessly during her pregnancy, which would otherwise be cruelty of a high order, the said factum was completely unproved, uh, completely unproved in the evidence. Full stop. Rather, the wife even denied her having ever visited the Arjikar hospital for such treatment. Full stop. Next para, from the complaints lodged with the police authorities, which were exhibited, particularly exhibit B, which is the complaint on the basis of which an FIR was lodged against the plaintiff, we find that serious allegations of the husband having beaten up the wife severely, inter alia, by kicking her on her stomach and which resulted in the fetus being uh, lost, as well as the husband having forcibly administered sleeping pills to the defendant respondent, upon which she allegedly came to the verge of death and approached her neighbors who took her to the hospital. Push up next para. However, not a single document, nor any neighbor have been adduced in evidence to corroborate such allegations of the first order against the plaintiff husband, which itself tantamounts to cruelty against the husband, which would make it impossible for the husband to live with the wife for the rest of his life, which is the cardinal yardstick of cruelty under section 13 within bracket 1 within bracket IA, small ia of the HMA. Whose up next para, the proposition laid down in A.R. Subramanian Supra by the learned single judge of the Madras High Court is well settled and has been reiterated in all relevant judgments of the Honorable Supreme Court, to the effect that there is no straitjacket formula to apply for mental cruelty, and each case depends on its own facts and has to be judged on such facts. Full stop. The prevalent legal position is that vague concepts of cruelty cannot be imported by the court from its own notions, but the court has to see the parties which are before it to ascertain whether the acts complained of amount to cruelty coming within the ambit of section 13 within bracket 1 within bracket small ia of the HMA. Full stop. In the present case, in view of the above discussions, we are of the opinion that the appellant husband proved cruelty by the respondent wife uh, to be entitled to a decree for divorce on such ground alone. Full stop. Next para. An interesting question has been posed before us as to whether irretrievable breakdown can now be treated to be a component of cruelty under section 13 within bracket 1 within bracket small ia of the HMA. Push up next para. Although in most of the judgments where the Honorable Supreme Court has granted a decree of dissolution of marriage by divorce on the ground of irretrievable breakdown, the Honorable Supreme Court resorted to Article 142 of the Constitution of India, which empowers the Supreme Court to pass any decree or order for the ends of justice and to do complete justice between the parties, fact remains that in Rakesh Raman's Supra, the Honorable Supreme Court, sitting in a two-judge bench, deviated from such established norm and touched the issue as to whether irretrievable breakdown can itself tantamount to cruelty coming within the ambit of within the purview of section 13 within bracket 1 within bracket small ia. full stop. We choose to quote the Supreme Court itself, Honorable Supreme Court itself, as held in the same said judgment, comma, particularly paragraphs 22 and 23 of the same. 22, 23 টা এটা থেকে করে দেবে 2023 2023 17 SCC ওই জাজমেন্টটা থেকে আমরা মার্কও করে দিচ্ছি। Which of next para? From the above statement of law by the Supreme Court, comma, it is clear that the Honorable Supreme Court categorically observed that a marriage which has broken down irretrievably spells SPELLS cruelty to both the parties, as in such a relationship each party is treating the other with cruelty. Full stop. Crucially, comma, the Honorable Supreme Court observed thereafter that it is therefore তারপর থেকে italics এ therefore থেকে italics এ it is therefore a ground for dissolution of marriage under section 13 within bracket 1 within bracket small ia of the act. Full stop. Next para. Insofar as the said statement of law is concerned, comma, the same, comma, ex facie, comma, was not an exercise under Article 142 of the Constitution of India, but a categorical law laid down by the apex court of the country, which has the force of law under Article 141 of the Constitution of India, comma, not stating that irretrievable breakdown, comma, on its own footing is a ground which has to be read into the statute, but incorporating the component of irretrievable breakdown as an ingredient of cruelty, which, comma, in turn, comma, is a ground for divorce under section 13 within bracket 1 within bracket small ia of the HMA. Full stop. Next para. Thus, comma, although it was not directly held that irretrievable breakdown, comma, which is not in the statute book, comma, is a standalone ground of divorce, comma, the same was by incorporation in within the definition of cruelty, comma, made a ground under section 13 within bracket 1 within bracket small ia in Rakesh Raman Supra. Full stop. Next para. In a subsequent judgment of a bench of similar strength in Rinku Baheti, Rinku Baheti versus Sandesh Sharda Supra, comma, the Honorable Supreme Court discussed a string of judgments where the Honorable Supreme Court had exercised its powers under Article 142 of the Constitution of India to grant divorce merely on the ground of irretrievable breakdown. Full stop. However, comma, as is well settled, comma, an exercise under section 142, Article 142 of the Constitution cannot be equated with law laid down under Article 141. Full stop. Let us now examine, comma, in such backdrop, comma, how Rakesh Raman Supra was dealt with in Rinku Baheti Supra. Full stop. Next para. In paragraph number 8.1 of the latter judgment, comma, the Honorable Supreme Court observed that the exercise of power by this court under Article 142 within bracket 1 to grant a decree of divorce and the factors to be considered while doing so have varied with facts and circumstances of each case. Full stop. Next para. Thereafter, comma, the Honorable Supreme Court, comma, in Rinku Baheti Supra, comma, stated that in the case of Rakesh Raman Supra, it was observed as follows, and thereafter quoted certain paragraphs of the said judgment. Full stop. Next para. After analyzing the said, after quoting the said judgment, comma, the Honorable Supreme Court, comma, in Rinku Baheti Supra considered several other judgments. Full stop. It is to be noted that while referring to all the other judgments, comma, including Vikas Kanaujia versus Sarita, reported at 2024 7 SCR 933, Prakash Chandra Joshi's case reported at 2024 1 SCR 697, Vineet Taneja's case, Vineet Taneja versus Ritu Johari's case, etc., the Honorable Supreme Court specifically observed that dissolution of marriage was granted in those cases under Article 142 within bracket 1 of the Constitution of India. First up, conspicuously, such an observation was not made with regard to the ratio laid down in Rakesh Raman versus Kavita. First up, next para, in the ultimate analysis, after considering all the previous judgments, the Honorable Supreme Court, in Rinku Baheti Supra, held that there remains no doubt that the said court has the power to grant a decree of divorce on the grounds of irretrievable breakdown of marriage by invoking its powers under Article 142 of the Constitution of India. Full stop. It was further observed that unlike a divorce proceeding before the family court, where the court is bound by the fault-divorce provisions contained in the HMA and other allied legislations, and thus has to necessarily appreciate the evidence to give a finding about whether a party has indeed committed the alleged matrimonial offense or not, the Honorable Supreme Court, while dealing with an application seeking divorce under Article 142 within bracket 1 of the Constitution, can depart from the said procedure as well as the substantive laws by acting as a problem solver and balancing out the equities between the conflicting claims. Next para. Thus, the question which fell for consideration before the Supreme Court in the said case was whether the Supreme Court has power under Article 142(1) of the Constitution to depart from the usual established procedure of proving the facts of a case and grant a decree of divorce as a problem solver, balancing out equities, under its powers within the contemplation of Article 142 within bracket 1 of the Constitution. Pushed up. The Supreme Court, the Honorable Supreme Court, however, in Rinku Baheti, was not deciding the question as to whether divorce can be granted on the ground of cruelty by incorporating irretrievable breakdown as a component of cruelty within the contemplation of section 13 within bracket 1 within bracket small ia of the HMA, thus merging the said ground within cruelty, which is a valid ground of divorce under the said act. Next para. Moreover, the Honorable Supreme Court did not either distinguish or overrule or deviate from the ratio laid down in Rakesh Raman Supra as discussed above while rendering the judgment in Rinku Baheti Supra. As such, it cannot be deduced by any stretch of imagination that the Honorable Supreme Court, in Rinku Baheti's judgment, distinguished or overruled the specific ratio laid down in Rakesh Raman Supra. Next para, it is also well settled that a judgment operates as a precedent only in the particular factual matrix of the said case and only in the context of what has actually been decided on the facts of the case and not something which can be deduced in a secondary or tertiary manner from the ratio laid down in such judgment. Viewed from such perspective, in Rinku Baheti Supra, the only question which fell for consideration was regarding a transfer while hearing a transfer petition filed by the petitioner wife under section 25 of the Code of Civil Procedure, as to whether the court, while hearing such a petition, can exercise its powers under Article 142 within 1 of the Constitution of India to grant a decree of divorce between the parties. Hence, on a comprehensive assessment of the above judgments, we are of the clear opinion that the Honorable Supreme Court, in Rakesh Raman Supra, categorically incorporated irretrievable breakdown as a component, as an ingredient of cruelty, which is a ground for divorce under section 13 within bracket 1 within bracket small ia of the HMA. Full stop. In the facts of the present case before us, comma, the parties are admittedly living separately for more than a decade, that is for 13 years from for more than over 13 years for more than 13 years from January 2011. Full stop. The parties do not have an issue, comma, which might have been a consideration as a bond which ought not to have been broken otherwise. Full stop. Next para. That apart, comma, there is nothing on record to indicate that throughout the pendency of the proceedings, comma, either of the parties made any endeavor to resume conjugal relationships with each other. Full stop. Next para. In the absence of the same, comma, we cannot but hold on the facts of the case that the marriage between the parties has broken down irretrievably, comma, which is a component of cruelty, comma, putting an additional edge to the ground of cruelty alleged by the husband. Full stop. In view of the above, comma, we are of the opinion that the learned trial judge erred in law in dismissing the divorce suit of the plaintiff stroke appellant on the ground of cruelty. Full stop. Accordingly, FAT 83 of 2022 is allowed ex parte, comma, thereby setting aside the impugned judgment and decree dated April 21, 2018, passed by the learned additional district and additional district and sessions judge, comma, fast track court, comma, Barasat, comma, district North 24 Parganas in matrimonial suit number 107 of 2011. Full stop. We hereby decree the said suit, comma, thereby granting a decree of divorce in favor of the appellant husband against the respondent wife on the ground of cruelty. Full stop. Next para. A formal decree be there will be no orders to cost. A formal decree be drawn up accordingly. Interim order, if any, stands vacant.
One thing.
Was there any alimony
There no, there was a alimony
in the appeal?
in the no, not in the appeal.
Yes.
Only one thing, fast track, fourth court.
In the
Page
pages,
15, will find
not there.
Judgment portion, will find.
Which page?
Judgment, page number 91. Fast track, fourth court at the top. That is the only.
Fast track, fourth court at Barasat.
I'm extremely grateful.
Thanks.
Extremely grateful.
আচ্ছা এই বইটা এই জাজমেন্টটা ওনাকে নেক্সট
Oh. Grateful, my lord.
একটা নামবো
for the applicant. I would be praying that if this order passed in item number 7 server, then it would be some beneficial to me, my lord. Here also, my lord, the suit filed under section 27 of Special Marriage Act in 2000. Marriage happened 31st January 2010. As per the plaint, my lord, I have stated the wife left.
only detailed breakdown.
Yes.
Nothing else. There were other points in
there was cruelty here also, my lord, cruelty, but cruelty was not somehow proved, my lord. And I have made allegations, documents were reduced, court did not consider them, and ultimately the suit was dismissed. The marriage happened in January 1st, 31st January 2010. As per my allegation, my lord, the wife left matrimonial house in 2013. Although in the written statement, she has stated that she has left matrimonial house 2015.
He's appearing for the somebody.
Nobody appeared, my lord. Notice twice notice was served. Thereafter, we have served to the department pursuant to lordship's direction. It was refused. The service was refused, my lord, as per the direction of the registrar Lojima.
It says no service return.
No, thereafter final order was.
If you can find out it.
Fight দেবেন
কিন্তু
fight
ফাইলে কোথায় রিফিউজ আছে ওনাকে দিন ওকে দিন করে দিন জল্লাদ হয়ে যাবে The phone number of Mr. Shottam Mukherjee, the previous landlord advocate. Does anybody know him? একবার পেপার উঠতে দাও তো অ্যাড্রেসটা কি আছে
একটু দেবেন এই অর্ডারটা
কোনো বার অ্যাসোসিয়েশন কোথাও আছে 13 নম্বরে বসি সব দেখিনি কোনো ঠিক আছে যদি বউ চায় তখন না লিবার্টি দিলেও করতে পারে পার্মানেন্ট অ্যালিমনিটা ভাবছিলাম No, Mr. Shottam Mukherjee, no, we were thinking about giving a leave to the wife to file a section 26, but we are not doing that, Mr. Banerjee, because she did not prefer make any application for alimony in the appeal also. Thank you. Yes.
Unfortunately, my paper book has also gone with the file.
এটা অনেকটা
না পেজ মার্ক করা ফ্ল্যাগ করা
কি এটাও অন্য বোধহয় refuse a good service. Yes. Let us hear the matter.
If either kindly
এটাতে একটা অর্ডার রেকর্ড করে নিতে প্রথমেই যে we find from the records that despite attempt to serve on the respondent comma the postal service returned with the endorsement refused full stop accordingly the appeal is ready as regards service comma since refusal is tantamount to good service full stop hence we take up the appeal for hearing. Yes.
If my lord kindly comes to page 8, my lord, of the paper book.
Yes.
It starts from the present, my lord. I am not taking the allegation.
Who adduced evidence on your behalf?
On my behalf, I and my landlady adduced evidence. On behalf of the wife herself adduced evidence.
Landlady to prove cruelty?
To prove the cruelty, my lord.
In her written statement, what was her stand?
In her written statement,
denial, apart from denial, anything, any allegation?
In her written statement, the allegation was, my lord, the petitioner used to, the wife respondent used to work in an engineering college as a lecturer. Thereafter, she was doing some tuition works. My allegation was that in every day she returned at 10:30, whereas the wife stated in her written statement as well as in evidence that only Saturdays she had tuitions. And in other days, she was silent over the issue. In the evening, she was never there, my lord. And when another allegation, my lord,
that by itself is not a cruelty.
Well,
Wife returning at 10:30.
I was deserted that time. And further, my lord, she wife went to complain before the Women Commission, wherein I was called there also. Allegations was made. No communications was made before. Directly coming to the Women Commission, and complaints were made to the.
What was the complaint made before the Women Commission?
The allegation was that she could not get hold of me over telephone. Accordingly, she lodged a complaint before the Women Commission.
Have you ever heard it before?
No.
Facts resonate. You have a deja vu on the facts. Anyway, so she phoned you and did not get you,
and
called you and did not
get me, and accordingly, without going.
Any of the complaints have been exhibited?
Yes, the complaint was exhibited.
Let us see one of the most interesting ones.
Kindly sees, my lord, page, only that document, page 2.
Yes, we had sent this to mediation.
Oh, the mediation ultimately not appeared, my lord.
No, at some stage the facts were before us. That's right. Anyway, page 2 of part 2.
Part 2.
No, this is.
This was a complaint.
This is not a complaint. Page 2 is notice of hearing.
Yes.
What is the complaint?
You are hereby requested personally attend to the Women Commission on so and so to discuss the matter and meet the undersigned with a nominated representative.
Yes, no. We are asking you where is the complaint? What was the complaint?
That was not here, my lord, but in the written statement as well as the evidence, she stated, my lord. If my lord kindly see
Let us see the written statement.
a written statement of
What was your allegation against her?
I have my allegation
Came late. That is not an allegation. That cruelty. That is cruelty.
that, and moreover, my lord,
10:30. She has a right to come back at 10:30.
it was a
Unless you had some specific allegation, she had an affair with somebody, or she was with somebody.
she
Came back at 10:30. Rightly so.
every day. My
Fully
lord,
agree with her.
every day she. Well, I from office I came 5:30.
You are a good boy. She was a bad girl. So what?
Well,
You will get a divorce degree on that ground. She came back at 10:30 at night. Her right. Unless there is some other allegation.
There was no other allegations.
Coming back at 10:30, Mr. Bhattacharya, then you would be, all of us would be out of our homes by now.
I should not say.
Coming back at 10:30.
Well, this was the allegation of the husband, my lord.
This itself is cruelty. You should not get a divorce.
And the lost
10:30.
And lost complaint.
This was the only allegation against her.
No. And my lord, the complaint before the Women Commission and police complaints were.
What was the let us see the written statement.
Written statement at page 27, my lord.
No, this was actually the only complaint. She came back at 10:30.
No. In written statement, my lord, he left in 2013.
Your complaint.
No, I have never made any complaint. My was
10:30.
The 10:30 was my allegation that she used to reside busy with her father in her father's house. She never came back in time to take care even to me, my lord.
What sort of care? Make you a cup of tea and all this.
But this was my grievance as a husband. I wanted the company of the wife, my lord, in the evening, but I couldn't get her company.
What do you do respectively?
I am a employee in Life Insurance Corporation, whereas the wife is a lecturer in an engineering college, and thereafter she has tuitions, private tuition. There is no issue. There is no issues, my lord.
But unlike the previous case, in your case, she has denied that she has left on that date. How can you get advantage of Rakesh Raman?
No. Thereafter also, my lord, after the dismissal of the suit, she didn't return back also. No endeavor was made to return back to the matrimonial house. The marriage has already now totally two different.
Any advocate appeared on their behalf when it was referred to mediation, Mr.
No.
At no stage they are appearing.
Notices was sent by the initially.
No advocate at any stage.
No. In the High Court, my lord, no advocate appeared, my lord.
Apparently, we were prompted by a complex. Although we have held that irritable breakdown can be introduced within this.
After the
but this is not a position where it's not a case where she's admitting when she left.
2000. Well, she has admitted in her written statement she has left in 2015 in the written statement.
মুশকিল করে দিলাম আগের জাজমেন্টে। Irritable breakdown, I am not required to prove.
Page 13.
We'll recall our previous judgment. We'll give a notice to Mr. Mukherjee. By itself, I mean, there has to be something else, Mr.
Page 16, she says that she has left in 2015. From 15 to 25.
Because there were several instances in the other case. In the written statement, there was an allegation, serious allegation that during her pregnancy, she was kicked. The baby was lost.
Here,
she was taken to hospital and she comes in evidence and says, no, I never went to that hospital.
Here, there is no such. But
and those complaints are still pending in the other case. Here, there is nothing. In that backdrop, we have stated that irritable breakdown can be incorporated in.
Here, my lord.
Here, you have alleged that she came home at 10:30 and did not make you tea or coffee, whatever you prefer.
Only not that. She has lodged complaint before the Women Commission, where I have.
Let us see. Women's Commission, what is her allegation on that?
Kindly.
The Women's Commission, the complaints have not been exhibited by either side.
No.
Only you are given a notice of hearing before the. We don't know what you did, why she went there.
Kindly, ultimately, nothing happened.
No,
Proceeding failed.
but let us see what is your allegation against you.
Kindly sees the affidavit in chief, my lord.
First written statement. What is the allegation?
In the written statement, my lord, kindly
Yes.
sees at page 27 onwards, it starts.
Yes.
Either page 29, paragraph 11. If my lord kindly sees, she states that page 11, my lord.
She took her she did her private tuitions and then came home. That's why she was
every
late.
day. It was my
Probably she imparted private tuition in her father's place.
Yes.
So why, how can that be cruelty?
I have requested her to come to my place and do the tuitions, but she refused, my lord.
We have a problem with your mindset.
And then kindly comes to page.
We have a problem with your mindset.
Page 33, my lord.
We really have a problem with your mindset.
Page 33, my lord.
33, yes.
Middle. Thereafter, suddenly the petitioner completely disappeared.
টিপিক্যাল একটা কেরানি মনে বউ পড়িয়ে আসে, বউ নিজের বাপের বাড়িতে টিউশন করে তারপর আসে সারা Her parental home?
Salt Lake.
Salt Lake. And yours?
Lake Town.
So her students of Salt Lake should come to Lake Town and take tuition. Just cross the that Bagjola Khal or whatever Khal. Not Bagjola. Some other Khal. Kestepur Khal, right?
Page 33, my lord. Kindly middle portion. Thereafter, suddenly the petitioner completely disappeared from his house. Middle portion.
Disappear means you.
Yes.
এই fact দেখেছি sure.
And did not even attend my phone call.
100%
Either respondent or her parents, finding no other alternative. Respondent rushed to the office of the Women Commission, Calcutta for her redressal and narrated the incidents.
Yes. So, হ্যাঁ আচ্ছা এটা হচ্ছে 33 পাতায় ছোট প্রিন্ট You completely disappeared from your house and did not attend any phone
I
call.
was in the office itself. She had my phone number, my colleague's number. She could have easily.
Throughout day and night you were in the
No, not at day itself, my lord. She suddenly says.
You completely disappeared from your house and did not even attend any phone call either from the respondent. So both of us, she's paranoid and you are complex. You're suffering from complexes. You should be married to each other. That is the punishment both of you should get.
She rushed to the office of the Women's Commission, Kolkata, for a redress and narrated the incidents happened after her marriage.
She states that she went to Women Commission. They advised her to file a proper police case, but due to social status, prestige of petitioner and his family, she did not lodge any complaint.
That time she didn't. Subsequently, she also lodged a complaint.
Lodged the complaint also.
Yes.
You have annexed that.
Yes, yes.
Show us that. Those were not annexed, exhibited.
Yes.
What yes? Which page?
Kindly seize, my lord. Page 4.
Or 2.
Page 5. Page 5. GD entry. These were the complaint lodged.
Page 5 gives the GD entry number. Where is the complaint?
That was not exhibited. That was not exhibited.
You could have called for that from the police station to mark it as through the court. You could do that.
That was not done.
You don't have the complaint even before us. What's she alleged against you?
That was not done.
How can we hold cruelty? Mr. Bhattacharya, yes, irretrievable breakdown, we understand. But it has to be read in the context. The backdrop has to be seen. You make ridiculous allegations against her.
But there's no.
Is this cruelty? She takes private tuition in her parents' house, which is in Salt Lake, comes back at 10:30 to Lake Town with a matrimonial home. And you say, no, you have to teach from here.
No, there are
allegations. She refuses. That is cruelty.
I kindly also seize, my lord, the landlady's evidence also, my lord, at page 68, my lord.
Landlady's voice is
68.
Open court is
Page 68.
Yes.
Examination.
Page 68. Where is her examination, chief? Landlady?
Page
yes,
64. 68, the cross examination. Second paragraph, my lord.
Hmm. Yes.
Dolon used to return home.
Dolon is she.
She.
Hmm.
At about so and so after giving tuitions. The dispute between them was regarding the matter that Dolon used to return at 9:30 p.m. I do not know any other.
This is cruelty on your part. So you should not get a duty.
Dolon and Kotodru used to say present on Sundays. I was present.
This is their only allegation that she came back late after imparting tuition.
But she thereafter, after disappearance in 2015, she also didn't came back also. She had never tried to reconcile also. No.
How does she explain that?
Nothing.
You are saying nothing. Let us see her.
Kindly see the written statement, my lord.
Let us see her evidence. Because she first. All right, in the written statement also you can show what was the stand regarding that. Did she admitted that she left into 2015?
Yes.
Where is that? Show us.
Kindly comes to the written statement, page 35.
Para 16, she says yes. Enough evidence, yes. Practically, respondent was staying with the petitioner till such and such. At the said rented house, both of them maintained conjugal rights. It is 200 years. They didn't pay. You went to a particular movie and then it never came together.
It was
must be the quality of the movie.
Movie was that was a movie was well, by that not.
It was good.
Yes.
Then why did you, after that you never came back together? That is your allegation. Came to that movie, we are not naming it. Went to a particular restaurant and never came back. What sort of this can be resolved between you?
No, it cannot be. What means
mediation has failed already.
Reconciliation has failed in the court bill also.
No child.
No issues.
অ্যাডমিট করছে এখানে রিভিউ লেভেলটা এখানে অ্যাডমিট করছে এনাফ এভিডেন্স এই 16 থেকে দেখুন read that কিন্তু এটা তো মানে ওরা তো দুজনে স্ট্যান্ডে অনর এটা বলেছিল কোন সালে সেটা হচ্ছে বোধহয় 2015 আজকে 10 বছর কেটে গেছে তারপর একই অবস্থা but in this then we'll be going one step further because that is the only on editorial ground. We are a bit hesitant on that.
Kindly comes to page 86 onwards of the cross-examination evidence in chief of the wife.
Yes, we agree with you. There is no satisfactory, no explanation at all for why she didn't regarding animus, the river tending. Only bare statement in para 18, but after that a decade has passed. No alimony application, obviously. No question. She is working also. Yes.
She has never claimed in the court bill also as well.
Acha, yes. Evidence where?
86.
Yes, 86. Hmm. একটা ধাপ শুধু ওই গ্রাউন্ডে দিয়ে দিই তারপর সুপ্রিম কোর্ট ঘুরিয়ে দেবে সুপ্রিম কোর্ট সেটা সেট করে বলে দিচ্ছে দ্যাট ইজ নট আ গ্রাউন্ড evidence
86, my lord.
we are in 86
74, my lord.
Hmm.
She states, my lord, suddenly that plaintiff completely disappeared from our house, so left town, and did not attend any call either. Finding no other, I rushed to the office of the Women Commission for my redress.
you
And
came back the same day
Yes.
বলেনি যে অন্যদিন ফিরেছে
Kindly sees 87 thereafter, my lord.
yes
Paragraph 77. I found the plaintiff, in spite of being qualified academically, was
paragraph
ignorant.
77
7.
yes found that the plaintiff yes so what
So these are the allegations made all time.
acha so you say that there were counter allegations also that this irretrievable breakdown on that she refers to certain documents complaint to chairperson she did not
That Women Commission.
complaint she did not refer to that
No.
Huh?
A complaint to the chairperson, West Bengal Commission for Women.
yes she refers to she says I have the following documents that was not exhibited
No.
by her also
That receipt was there. That was on her part only.
yes her part yes letter from let us see page we don't find the complaint anywhere so how do you know whether there was any false allegation
Both.
no all the exhibits are here annexed আবার রাখি সামনে নিয়ে যেতে জ্ঞান দিয়েছে ভেঙে গেছে in the Hindu Marriage Act. So if there is irretrievable breakdown, yes, if that's shown from the records, beyond doubt, then we are all right with that proposition, Rakesh Raman proposition. There has to be irretrievable breakdown from both sides. I cannot take advantage. I leave my wife and then say that there's an irretrievable breakdown. I cannot do that. But here, 10 years have elapsed and there is no animus revertandi. That we can find from the records.
A pendency of this suit also.
ওইটাই বলেছে সেটা তো 15 সালে বলেছিল তারপর থেকে
It didn't appear.
mediation sheet never appeared also.
Never appeared.
Really কি করবো করার না না 100 বার আগে বলে দিচ্ছি তো রেসপেক্ট হয়ে আছে The plaintiff husband has preferred the appeal against the dismissal of his suit for divorce. Push up next para. The allegations leveled primarily against the respondent wife was that the respondent wife, comma, after her job as a lecturer in a college, comma, used to impart private tuition at her parental home in Salt Lake City, within bracket Bidhan Nagar, and thereafter came to the matrimonial home in Lake Town after 8:30 p.m. Full stop next para. This led to acrimony between the parties. Full stop. It is alleged that subsequently the wife also lodged a complaint with the West Bengal Women's Commission merely on the ground that the plaintiff was not attending her phone calls on a particular day. Full stop next para. It is submitted by learned counsel for the appellant that apart from the same comma, the respondent wife also lodged complaint before the police on similar ground. Full stop next para. It is argued that the marriage between the parties has irretrievably broken down, comma, which is evident from the fact that the respondent wife has never appeared to contest the appeal and even chose to abstain from the mediation process for which the matter was referred by this court. For the next para, it is contended that there is nothing on record to show that for the last decade, comma, the wife ever made any attempt to resume matrimonial conjugal life with the appellant. For the next para, learned counsel for the appellant places reliance on the examination in chief of the respondent wife, from where it appears that she had stated that she had lodged a complaint with the Women's Commission for her redress and narrated some of the incidents that happened after her marriage, including intentional disappearance of the plaintiff stroke appellant stroke husband. For some next para, it is argued that such complaints being lodged at the drop of a hat, comma, without any solid basis, comma, itself indicates acts of cruelty on the part of the wife. For some next para, learned counsel for the appellant argues that the appellant, comma, as the husband, comma, was entitled to have at least the company of his wife, comma, the respondent, comma, which he was deprived of, comma, since even after work for the day, comma, the wife chose to impart private tuition from her parental home and return late at night, comma, by refuting the repeated offers given by the plaintiff appellant for the respondent wife to impart such tuition from the matrimonial home. Full stop. Next para. That apart, comma, it is argued that give copies of those judgments again. Rakesh Ramanan. Apart from that, comma, the marriage between the parties, comma, it is submitted, comma, has broken down irretrievably. Full stop. Placing reliance on those copies were with your paper.
No, that Mr. Papu went for to make photocopies. Oh, I don't know.
Mr. Papu is there. Mr. Papu has a surname. Learned Council places reliance on Rakesh Raman versus Kavita, reported at 2023 3 SCR 552, where the Honorable Supreme Court had observed that irretrievable breakdown spells cruelty to both the parties and tantamounts to each party treating the other with cruelty, comma, which is therefore a ground for dissolution of marriage under section 13 within bracket 1 within bracket 1 small a of the Hindu Marriage Act bracket HMA. Which of next para, although the said judgment was later considered along with other judgments in Rinku Baheti, RINKU BAHETI versus Sandesh Sharda, Sandesh Sharda, however, comma, in the latter judgment, comma, although the Supreme Court passed a decree of divorce on the ground under Article 142 of the Constitution of India, comma, the proposition laid down in Rakesh Raman Supra was never deviated from. Thus, comma, it is argued that at least on the ground of irretrievable breakdown, comma, the trial judge ought to have granted a decree of divorce. Next para. From the materials on record, we do not find anything to indicate as to the exact nature of the complaints made by the respondent wife before the Women's Commission or the police authorities. Rather, comma, from her communication to the inspector in charge of the Lake Town police station, comma, which was marked as Exhibit B, comma, it merely appears that the wife requested the police to recall her earlier GD within bracket number 1047 dated 21 07 2001 2010 or something 2010 bracket closed against her husband and in-laws, comma, since she was allegedly trying to sort out the matter through discussion. It was also informed to the police by the respondent wife that through West Bengal Women's Commission mediation, comma, the parties had come to the decision that the plaintiff stroke husband would be living with the respondent wife in their Lake Town rented flat from January 31, 2012. Although the concerned general diary entry numbers and the notice of hearing before the Women's Commission were exhibited, comma, we failed to find any particulars of the complaints lodged against the husband. Next para. Insofar as the late return of the wife is concerned, comma, we agree with the conclusion of the learned trial judge that ipso facto such conduct on the part of the wife cannot be construed to be cruelty as such. In any event, comma, there is no specific allegation of the wife being embroiled in any other relationship or otherwise. Both parties admit that the respondent wife was merely imparting private tuitions in her parental home during the evening, comma, for which she could not come home earlier. Thus, we are of the clear opinion that the same did not tantamount to cruelty on its own footing. Next para, the only other factor which is required to be considered is whether the plaintiff husband is entitled to a divorce decree on the ground of irretrievable breakdown of marriage. Although, in isolation, the same is not a ground of marriage recognized under the HMA, a question arises in view of the ratio laid down in Ramesh Rakesh Raman Supra as to whether irretrievable breakdown can be read into the expression double inverted cruelty as used in section 13 within bracket 1 within bracket small ia, of the HMA, which is a valid ground of divorce. Next para, on the factual premise, we find from the written statement of the respondent wife that she admitted in paragraph number 16 thereof that practically she was staying with the petitioner, that is the appellant husband, till May, 2015 at their rented house, and both of them maintained conjugal life in all respect in spite of the differences in some petty matters. Full stop. Next para. It is even alleged that during the said period, that during the said month of May 2015, they attended a, a movie as well as went to a restaurant and had spent time together. Full stop. However, those statements were made in the context of denying the allegation of the husband that the parties were living separately since May 9, 2013. Full stop. However, conspicuously, the written statement of the wife does not contain any explanation whatsoever as to why, thereafter, the parties did not resume uh, their conjugal life. Full stop. Next para. Even in the evidence of the wife, we do not find any whisper as to why she did not revert back to the husband. Full stop. In paragraph 17 of the written statement, the respondent wife alleged that in spite of her best efforts and or endeavor towards the appellant husband, he did not hesitate to level bundle of false and frivolous allegations against the respondent wife and her parents, knowing fully well that the respondent was leading a peaceful conjugal life and always complied all the requisition not only of the appellant but also of his parents without raising any objection. It is further alleged in the said paragraph of the written statement that on numerous occasions the respondent went to her in-laws' house at Ghatal and stayed there for considerable period of time as per the dictum of the petitioner stroke husband and tried her level best to satisfy them fully. But unfortunately, neither the petitioner husband nor any member of his family expressed their minimum satisfaction upon the respondent, rather used to consider the respondent as an outsider. Full stop. Next para. It is also alleged that the respondent wife, only for leading conjugal life, bore buari, all such behavior. Full stop. Next para. In the examination in chief of the wife, she alleges that after marriage she tried her level best to satisfy the plaintiff stroke husband and his family members, but unfortunately neither the plaintiff nor his parents ever expressed happiness and always tossed her by various means. Tossed her to double inverted tossed kothara TOSSED. She further states, next para, she further states that suddenly the plaintiff completely disappeared, double inverted completely disappeared, double inverted close, from their house and did not attend any phone call either from her or from her parents, and finding no other alternative, she rushed to the office of the Women's Commission for redress and narrated some of the incidents that happened after her marriage, including the intentional disappearance of the plaintiff. Next para. She also admits in her examination chief that the Women's Commission advised her to approach the police, but considering the social status stroke prestige of the plaintiff and his family members, she did not lodge any police case against the plaintiff. Full stop. Next para. However, such contention is belied from the exhibits, in particular Exhibit B, which is a letter by the respondent wife to the inspector in charge of the Lake Town Police Station, referring to an earlier GD entry within bracket number 1047 dated July 21, 2010, bracket closed, against her husband and in-laws, which she was, which according to her, she was trying to sort out. Thus, from her own admitted document, that is Exhibit B, it is clear that she had lodged a GD entry on July 21, 2010 against her husband and in-laws, which she conveniently denies in her examination in chief as well as cross examination. Next para. The respondent wife further stated in her evidence that the plaintiff, in spite of being qualified academically, was ignorant of the social status, reputation, and respect of the wife's parents, and practiced the habit of leveling false and fictitious allegations without any foundation against the respondent and her parents, and used insulting and abusive language against her in front of friends, relatives, and outsiders, and that the plaintiff had been constantly nagging and insulting her with unending accusations and false imputations and frequent use of harsh and pungent tongue in presence of outsiders. The respondent wife further alleged in her evidence that she was castigated innumerable times in front of outsiders by the plaintiff wife by passing sarcastic remarks and usage of abominable language, and that the plaintiff husband did not even hesitate to assault her physically without any reason or rhyme. Next para. However, we do not find an iota of evidence on record to substantiate such additional allegation made in her evidence that she was assaulted physically by the plaintiff husband, which is not borne out in her by her written statement as well. Next para. Hence, in view of the nature of the acrimony as borne out by the evidence of the wife herself, as well as certain allegations leveled against the husband which are not corroborated by evidence, as well as the tendency to suppress complaint lodged before the police, indicates clearly that the marriage between the parties has broken beyond repair. Next para. Moreover, the wife, we cannot overlook the fact that the respondent wife has never appeared, despite service of notice, to contest the present appeal, which has been preferred by the husband against the dismissal of his divorce suit. Moreover, a tacit compliance of the wife is also found from her deliberate absence from the mediation process which was attempted between the parties by the order of court. By her absence throughout the present appeal, it transpires that the wife is not interested to contest the appeal itself, which, if allowed, would have the effect of granting a divorce decree against the wife. Next para. Moreover, the element of italic say animus desirendi, DEACRENDI, RANDI, desirendi is animus revertendi, revert ANDI. Revertendi is completely absent on the part of both sides in the present case for the decade which has passed from the filing of the suit in the year 2015 till date. Next para. As such, it is evident that the marriage between the parties has irretrievably broken down. While saying so, we make it clear that we are not oblivious of the statement made in paragraph number 18 of the written statement of the wife, to the effect that the true fabrics of the married life, still exists, and it requires only some cooperation and minimum sacrifice which the petitioner denied to provide, and on the other hand, misjudging the respondent in each and every manner. Full stop. She further stated therein that practically, the dream of conjugal life has been disturbed due to the continuous interference of the petitioner's own family, specifically his mother, but the respondent still believed that the intervention of the court would let them follow the right path in respect of leading conjugal life afresh. Full stop. Next para, thus, the apparent statement that the true fabric of the married life still subsisted is fully loaded with underlying nuances which has to be read between the lines in the said paragraph. Full stop. In each and every phrase used in the said paragraph, the respondent wife makes the continuance of conjugal life conditional upon several factors, including minimum sacrifice by the appellant husband as well as interference by the court. Full stop. Next para. However, when the court did interfere in the appeal by sending the matter to mediation, the wife chose not to appear there. Full stop. Next para. In paragraph number 81 of the examination in chief, the wife stated that she was willing to adjust herself and accept whatever terms and conditions that may be imposed upon her by the court to lead a happy married life with her husband, and shall gladly accept those terms to its word. Full stop. Next para. The most unfortunate moments in a matrimonial relationship occur when one of the spouses has to say that the leading of a happy conjugal married life would be entirely dependent on terms and conditions imposed by an external agency, be it the court or the family of either of the parties. Full stop. Thus, from the loaded statements made in the said paragraph of the written statement and evidence of the wife themselves, we find that the wife merely paid lip service to her intention to come back, but from her conduct, it is evident that even the respondent wife is not willing to resume the conjugal right between the parties. Full stop. Next para. Read in the above perspective, we are of the opinion that the marriage between the parties has irretrievably broken down. Full stop. The only factor which remains to be considered is that in the absence of double inverted with irretrievable breakdown as a ground of divorce within the four corners of the HMA, whether the court can grant such a divorce decree on such ground. Full stop. Next para. There cannot be any manner of doubt, and as held in Rinku Bahati Supra, that the Supreme Court, under its powers vested in Article 142 of the Constitution of India, has ample jurisdiction to pass any decree or order which it deems fit for doing complete justice between the parties and or for the ends of justice. Full stop. However, the high courts are not empowered to do so and have to travel within the periphery of legislative intent as reflected in the statutes and stroke or judgments of the Supreme Court, which are binding as precedents within the contemplation of Article 141 of the Constitution of India, being law, being having the force of law. Full stop. Next para. Read in such context, in Rakesh Raman versus Kavita Supra, the Supreme Court categorically observed that irretrievable breakdown of a marriage may not be a ground for dissolution of marriage under the HMA, but cruelty is. Full stop. A marriage, it was held, can be dissolved by a decree of divorce, inter alia on the ground that the other party has, after the solemnization of the marriage, treated the petitioner with cruelty. Full stop. In the considered opinion of the Supreme Court as expressed in Rakesh Raman Supra, a marital relationship which has only become more bitter and acrimonious over the years, does nothing but inflict cruelty on both the sides. Full stop. The Honorable Supreme Court further observed that to keep the facade, FSCAD, of this broken marriage alive would be doing injustice to both the parties. Full stop. Next para, a marriage which has broken down irretrievably, comma, in the opinion of the Honorable Supreme Court, comma, spells cruelty to both the parties, as in such a relationship, each party is treating the other with cruelty. Full stop. Crucially, comma, the Honorable Supreme Court held that, therefore, it is a ground for dissolution of marriage under Section 13 within bracket 1 within bracket small ia of the HMA. Full stop. In Rinku Behati Supra, comma, the Honorable Supreme Court, comma, while deciding a petition under Section 25 of the Code of Civil Procedure for transfer, comma, considered whether it could pass a decree of divorce under Article 142 and did so. Full stop. Next para. In such context, the previous judgments of the Supreme Court were considered. Full stop. However, comma, while considering Rakesh Raman Supra, comma, the Honorable Supreme Court of coordinate strength, comma, in Rinku Behati Supra, comma, did not overrule, comma, distinguish or deviate from the law laid down in Rakesh Raman Supra, which in our opinion, in our humble opinion, comma, comes within the ambit of Article 141 of the Constitution of India, comma, since the Supreme Court categorically held that although on a standalone footing, irretrievable breakdown cannot be a ground for dissolution of marriage, comma, read as a component of cruelty, comma, which is a ground under Section 13 within bracket 1 within bracket small ia of the HMA, comma, the said ground can be considered to entitle the petitioner to a decree of divorce. Full stop. Next para. We cannot but overlook the evolution of matrimonial law in India in such context, full stop, whereas under the personal law, such as the HMA, comma, previously Hindu marriage was considered to be a sacrament, comma, times have evolved and a contractual ingredient has slowly been read into it. First of the court's intervention was widened with the enactment of the Hindu Marriage Act 1955 in matrimonial relationships. Full stop. Seen in such context, comma, the sacramental footing which a Hindu marriage previously originally had has undergone a sea change with evolution of society, and at present, comma, courts have been repeatedly holding that parties ought not to be bound to a dead marriage, comma, if there is no chance of reconciliation. Full stop. The Honorable Supreme Court, comma, in a catena of judgments, comma, has exercised its powers under Article 142 of the Constitution of India to grant dissolution of marriage on the ground of irretrievable breakdown alone. Full stop. Thus, hence, comma, in Rakesh Raman Supra, comma, what was done by the Honorable Supreme Court was to give a seal of Article 141 by laying down the law formally that irretrievable breakdown, comma, if proved, comma, is a component of cruelty and in such manner, comma, comes within the purview of Section 13 within bracket 1 within bracket small ia of the HMA, which is a valid ground for dissolution of marriage on the ground of cruelty. Full stop. Next para. Read in such context and in view of our above factual observations, comma, we are of the opinion that the learned trial judge erred in law in dismissing the divorce suit of the appellant. Full stop. Accordingly, FA number 160 of 2022 is allowed on contest, comma, allowed ex parte, comma, thereby setting aside the impugned judgment and decree dated March 7, 2022, passed by the learned additional district judge, 5th Court at Barasat District, North 24 Parganas. You have not given the number of the suit.
Matrimonial suit number 101.
In matrimonial suit number 1055 of 2015, full stop. The said suit is hereby decreed, comma, thereby dissolving the marriage between the parties by a decree of divorce on the ground of cruelty. Full stop. Interim order, if any, stands vacated. There will be no orders to cost. Urgent certified copy. A formal decree be drawn up accordingly. আগেরটাতে বলে দিও তো formal decree অনেক দিতে বলে formal decree be drawn up accordingly. Interim order will be vacated. There was no alimony order during pendency. She still works well.
Never applied also. She never applied also.
She never applied.
Deeply objected.
Thank you. Thank you.
Thank you.
Item number 9, Lordship.
I'm for the
Yes.
appellant
But the
wife.
matrimonial matter for today. We've already done sufficient wrong.
Kindly make
Breaking
it
too
part
much.
heard and keep it on next Thursday, madam.
You're also on the.
Yes,
You have been
uh,
supplying the judgments to them. Must be same.
Same case, it all.
Start your matter. Start your matter.
My lord.
Yes, you are saying something.
Lordship, Mr. Mohinder Prasad Gupta appearing this matter for the respondent, Lordship, but his father has died, Lordship,
Father, when?
Saturday, Lordship.
When should you keep it? Tell us.
2 weeks.
After vacation.
Yes, Lordship.
He has to make alternative arrangements.
Kindly keep it on next Thursday.
When did the demise take place? You said.
Lordship.
Did he die? His father.
Saturday, Lordship.
He can come back next Thursday. What is the
Lordship.
difficulty? We'll start the matter today.
He said that, Lordship, 2 weeks time, Lordship.
Tell him we said no. Yes, start the matter.
Lordship, next Thursday, Lordship.
We'll start the matter. There are 13 minutes left.
My lord, the appellant before your lordship is a wife, and her application matrimonial suit under section 27B and D under the ground of.
So,
this.
We should keep it at least next week.
Yes, yes, no difficulty, my lord.
That ground, I mean, we should
Yes,
not
yes.
Start the matter today.
Can it be made as part of my little as a fixed matter, man?
No. An adjournment is sought on the ground of bereavement in the family of learned counsel for the respondent. Full accordingly, let the matter stand adjourned till December 18, 2025.
My lord, at least some preference in the list, my lord.
It has already gone up automatically.
My lord, other
Oh,
intra-court appeals come. That's why, man.
No, Thursday to আমরা civil matter যাবে উল্টো হবে
If that preference is must longer.
Since, however, since due to paucity of time, the matter cannot be taken up to cannot be concluded today in any event, we commence hearing learned counsel for the appellant. Full stop. Let the matter be full stop heard in part for further hearing on the returnable date.
Grateful, my lord.
Will appear under the heading part heard telling. We have not heard it, but will keep it at part heard.
Grateful, my lord. Extremely grateful. My
Next.
lord, may I submit my affidavits?
No, everything on that. Yes.
Baba.
But I'm for the appellant, madam.
Mohendra Gupta. Mohendra Gupta নাম একদম মহেন্দ্র গুপ্তের নামটা কাট Why have you given the name of Mr. Mohendra Gupta? On his ground, you are asking for time. Have you gone out of your wits?
No, Lordship, pardon me, Lordship.
Thank God you have not given son of. Yes, Mr. Ghosh, what is the matter?
My lord,
This is common sense, ma'am. This has nothing to do with you being a junior or a senior. Common sense. You ask for adjournment on his father's bereavement ground, we grant you that time, and you are giving his name. Is he short of money? This is unbelievable.
Pardon me, Lordship.
What, pardon me? You're still laughing. Anyway, Mr. Ghosh, please.
The husband is the appellant before your lordship.
Yes.
But he challenged his
You are tired with these husbands. Yes. Respondent.
Lordship was directed on the last occasion to contact the client through legal aid because
Legal aid?
We have been engaged through High Court legal.
The wife is not contesting. They are separated since 2002.
No, but legal aid. So what? So
We have given a letter also to the secretary legal aid.
I have served a notice further upon her.
no, this was given to the legal aid.
Because the direction was to contact through legal aid, Lordship.
Contact the respondent. She's not appearing.
No. And unless and until she comes to meet us, we cannot.
How can?
Also.
No, you cannot.
She never appeared before the learned
She's
trial
not
court.
appearing deliberately. We can keep this on record then. You keep a copy with you. No, for your own protection, I mean, you keep a copy with you. Later on, if allegations are leveled against you, Mr. Ghosh will take this up on the next day.
Much obliged, my lord.
We'll
Refused. I
record an
served
order.
notice.
We'll
He
record an order.
refused.
We'll record an order.
May hands up the appeal service. He refused.
Oh, acha, correct.
And even she did not appear in the learned trial court also.
Expedited dismissal.
Expedited dismissal.
The affidavits of service filed to be kept on record, which indicates that service has been effected on the respondent wife, who's of however, the respondent wife has not appeared thereafter. Next para. Learned counsel having instruction to learned counsel engaged by the legal services authorities as per previous direction of this court appear and submit before the court that despite attempts to contact the respondent personally, she has not yet contacted said learned counsel. Next para, thus, it transpires that the respondent is not interested in contesting the matter. Be that as it may, in order to enable learned counsel engaged by the legal services authority to bring on record the communications attempted to be made to the respondent, let the matter stand adjourned till December 18, 2025, when it will be listed under the same heading. Please file.
Keep this on record. You have scanned.
You have?
Yes.
তো লাস্ট লাইনটা তাহলে ছেড়ে দিন, লাস্ট লাইনটা ছেড়ে দিন। হাউএভার, যেটা বললাম না না, প্রথম প্যারাগ্রাফটা বললাম ও এফিডেভিট অফ সার্ভিস করেছে, এই অর্ডারটা কেটে দিন, আমি নতুন করে বলে দিচ্ছি। Affidavit of service filed today, which indicates good service have been effected on the respondents. Next para, learned counsel having instruction to learned counsel having been engaged by the Calcutta High Court Legal Services Committee pursuant to a direction dated August 5, 2025 of a coordinate bench, in order to represent the respondent, express their inability in that regard, since despite all attempts to establish contact with the respondent, the said learned advocates failed to establish such contact. Next para, a letter to the Secretary, High Court Legal Services Authority by the said learned advocate indicating the above is filed in court today, carrying the receipt by the Legal Services Authority. Next para, thus, it transpires that the respondent wife is not interested in contesting the appeal. Accordingly, recording appreciation for their services, the learned counsel engaged by the legal services, Calcutta High Court Legal Services Authority are discharged from further appearing in the matter. The appeal is taken up for hearing expert. You start the appeal. Your start. Yes. Cruelty.
Marriage, yes, my lord. Cruelty and reversion. Marriage was taken place in 2001. Since 2002, my lord, they are separated. Now, initially, in the year 2006, a suit has been filed by the husband against the wife. Number the suit on the count of deserts.
From 2001, they are living separately. It's admitted.
It is admitted.
There is no child.
There is a child.
There is a child.
There is a child.
What is the age?
Now his age is 22. 22, yes. She born on 15th.
Living with the wife.
Living with the wife. 15th April 2000.
Any alimony being paid by you?
No, nothing has been claimed. On 125 application was filed, but thereafter they further not proceeded. Oh, yes, but 125 has been filed, and I have been directed to pay rupees 10,000, and I am paying. Wife is not contesting the divorce suit in the London trial court also.
No section 24 or
no, nothing
in this appeal or this suit.
No. But what happened in 2006? Initially, I filed a suit.
She filed a written statement
in the trial court.
Suit.
Initially, 2006, I have filed a suit.
She filed a written statement.
At that point of time, it was filed. The suit was dismissed. The order came up before the Your Lordship's court. This honorable court pleased to dismiss the appeal on the ground that there is no such desertion. It was the order was passed in 2008. She did not return. I further filed the second suit in the 2019.
Mr. Ghosh, please just give us a list of dates.
I had to pre brief
Let us
because it's a
brief list of just
yes,
these dates.
Yes, my lord.
Not details of
there, since there's a
on
earlier
the such and such date I took her to a restaurant. She kicked me on the backside.
No. Because earlier there was an earlier suit.
On this date the first suit was filed. That was dismissed. This appeal remanded, and only these dates.
Yes.
So come prepared with the list of date on the. We'll keep it on the. During hearing, it transpires that certain dates are relevant for adjudication of the appeal. Accordingly, the learned advocate for the appellant is requested to file a short list of dates. To enable the learned advocate to prepare the same, the matter is adjourned till December 18, 2025. Come back with the list of dates. We'll hear out.
Much obliged.
Not to do. Acha, order record. None appears for the parties. Let the matters appearing. Come. 11.
11.
Yes.
Lord, wife is the appellant before your lordship in a suit.
আমাদের কি শুধু ম্যাট্রিমোনিয়াল ডিটেইলস এখন?
Before your lordship in a suit for divorce filed by the husband on the ground of cruelty. Decreed. And permanent alimony was granted, my lord, to the tune of rupees 5 lakhs only. Now, my lord, against that, my lord, the appeal has been
paid.
No, we have preferred an appeal.
Oh, no.
Wife has preferred an appeal.
Yes.
Permanent.
Yes. You did not take it.
Yes. Now, my lord, admittedly, living separately since 2003.
3.
And, my lord, there is, my lord,
then why are you challenging the divorce?
Yes. My lord, decree has been passed on the ground that since the cruelty has not been disproved by the wife.
That ground, but irretrievable.
But I have essentially, my lord, to be very candid, my lord, the alimony is
permanent alimony now.
Yes.
Quantum.
Yes. My lord, he retired, my lord. His last drawn salary was around 90,000. Ad interim, my lord, the alimony pendentiality was, my lord, granted by this court 20,000. Thereafter, my lord, after his retirement, my lord, it has been reduced to 15,000. My lord, 5 lakh is a very meager amount. He has
retired.
He has retired. That's why it has been reduced to 15,000 by this honorable bench.
So now 15,000.
No, that I am getting.
What is his income after pension per month?
That, my lord, he has disclosed it, my lord. My lord, what he has done, my lord, he has commuted a lump sum amount of the pension just for this purpose.
Whatever he disclosed, we have to proceed.
But he has come, my lord, Mr. Arun Bhattacharya is appearing for the.
They give a notice to him.
Yeah, my lord, he came to me yesterday.
To give a written in writing so that we can take up expertise.
Yes, he is aware of that because I told him yesterday also, my lord.
So he might not have anticipated at this hour.
Yes. My lord, as your lordship did.
None appears for the respondent at the time of call. The learned advocate for the appellant is requested to serve a notice on his counterpart appearing for the respondent, indicating that the matter shall be listed under the same heading on December 18, 2025. Please come back on that date, Mr. Rao. Come with on which date the appellant shall file a receipt in that regard.
Great.
If it doesn't appear, we'll take up the matter.
Yes.
My lord, I'm being led by Mr. Surya Prasad Chattopadhyay and
which matter? Yes. Callta করুন.
For the respondent.
My lord, I'm being led by Mr. Surya Prasad Chattopadhyay and Mr. Ankit Chatterjee. They are both engaged in court number 29.
You start now. That is a brief.
My lord, I'm not briefed in this matter. I am not the AOR also.
How long are you practicing?
2 months.
Paper book a copy ওনাকে দিন. একটা copy আমাদের দিন. Start from there. What have you challenged? Yes. He challenged. Have you gone through the paper book? Any paper book?
No.
Read the index. What is the chronology?
An application for dissolution of marriage.
So
Written
therefore, there was a divorce suit.
Yes, my lord.
Written statement against that. Court frames issues on that. What are the issues? Then examination chief is the evidence. That continues up to item 12. Item 13 is the judgment.
Yes, my lord.
A plaint is filed, written statement filed, the evidence is laid, issues are framed, court decides the issues. Judgment starts at page 13. You are for whom?
For the appellant.
Who is the appellant?
Shorvani Mutunda.
So she is the wife, obviously. Divorce suit. So see, read it out from the judgment. Judgment ends at page 112. Read it for us whether your suit was dismissed or their suit was allowed, decreed. Read from page 112 of the.
My lord, I'm reading from page number 110.
Right.
This court can come to the conclusion that relationship in between the parties has now become a dead wood and that there is no possibility for resumption. As such, if the decree of dissolution of their marriage passed in the instant suit, the purpose of justice will suffice.
Not suffice. Continue.
Now, as regards the custody of minor child or his maintenance, the matter may be resolved in separate suit. However, the respondent may file appropriate petition for maintenance of a child as envisaged in section 26 of the Hindu Marriage Act.
Skip that, skip para 38, para 39. As a result, the suit succeeds. So petitioner gets a degree of divorce.
Yes, ma'am.
Therefore, you are the wife. So the husband, her client, your learned friend's client got a degree for divorce against you. What is your ground of challenge? Mr. Chattopadhyay, on the next day he has to start and then you take over.
The ground of challenge is only that the desertion point which has been taken, but that has been beyond the records. It was a constructive desertion as per your lordship.
No desertion is
Because I'll show the
But
exhibits.
admittedly, since 2006, they are
Irretrievable breakdown, lordship knows but it cannot be granted by the trial.
Lordship, till now, no restitution, conjugal.
You bring copies of those judgments, this Rakesh Raman and.
Yes, I have there.
Yeah.
I
And
Come back. এটা part hard in part for further hearing on 18th December 18th.
sharing.
Instead of 18th, any date,
No other date. That is our favorite date.
only some personal difficulty on 18th.
No personal. What personal? No personal. Every difficulty cannot be personal.
Should I submit a list of dates today?
On that, keep it with you. If it is misplaced, it will be. Let it be in the list, Mr. Chattopadhyay. If you're in difficulty, there are other part matters also before you. If you can't reach, then you are saved.
He'll start.
Right.